Much awaited CA Interlaw Exceptional Topics Marathon is finally in front of you. Exceptional topics are the areas where ICA tests your presence of mind, your conceptual clarity. In the examination hall, every one of us will face pressure. During the pressure situation, reading a tricky question automatically our confidence level will come down. To overcome this problem, I am doing this Exceptional Topics Marathon. And this is not the first time we are doing it. September 25 attempt, 59 marks came from Exceptional Topics Marathon. Jan 26 attempt, 70 marks came from Exceptional Topics Marathon. And this time also, you can trust me, you can expect 70 plus marks from this Exceptional Topics Marathon. This time, I revised not only exceptional topics, but also important areas. And throughout this marathon, I used 3 resources. First one, Exceptional Topics PDF. Next, my handwritten notes and concept notes. Sir, where to download these resources? Just go through rest of our CA/CMA website. So click on free resources. Here you will find P2 Corporate and Other Laws, D.V. Subramaniam sir. So here you can download concept notes, question bank, running notes, handwritten running notes. And next, come back, expected questions May 26, survival plan. Click on this. Here you will find P2 Law Exceptional Topics PDF. Trust me, if you sincerely watch this 3 or 45 minutes marathon lecture, your confidence will change completely. Stay with me, watch till the end, revise with full focus, take proper notes and convert your fear into the marks. I wish you all the best. Let's begin. Let's begin with the first chapter, preliminary. First one, private company. AOA of a private company should contain 3 important clauses, namely restricts transfer of shares, limits number of members to 200, prohibits invitation to public to subscribe its securities. While counting number of members, all the present employees and past employees who became members during their employment tenure are excluded, and joint shareholders are counted as a single member. On this point, we had a practical question. Let's see. So given company is a public company and there are 230 members in the company. Directors of the company propose to convert it into a private company. Advise whether reduction in number of members is necessary. Let's see the details. Directors and their relatives counted. Employees, present employees not counted. Ex-employees, shares were allotted when they were employees. So past employees who became members during their employment tenure not counted, 0. 5 couples holding shares jointly in the name of husband and wife. Joint shareholders are considered as a single member. So here 5 will be counted, others 145. So total 200. Since the number of members are within the limit of 200, company can be converted into private company without reduction in number of members. Without reduction in number of members. Next point, small company. To avail the benefit of small company status. To avail the status of small company, 3 conditions to be satisfied. 3. First one, it should not be a public company. Second one, turnover in the preceding financial year should not exceed 40 crores. Paid up share capital should not exceed 4 crores. For May 26 attempt students, turnover, paid up share capital, there is no change in limits, up to 40 crores turnover, up to 4 crores paid up share capital. But the important point is, here you need to verify this criteria. Here you need to check these conditions every year. Every year. That means once small company status is lost, will it be lost forever? No, 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 no. Year on year you need to check. For example, first year, yes, I'm talking about private limited company. First year, turnover 10 crores, paid up share capital 1 crore. So for second year, the status of company is small company, because you need to check financial parameters of preceding financial year. Next one, turnover 60 crores. There is no change in paid up share capital. Now for third year, what is the status of a company? Not a small company. Not a small company. But in the third year, the turnover fall into 30 crores, paid up share capital same 1 crore. Now what is the status of the company? Fourth year, what is the status of the company? Fourth year, yes, it is a small company. That means once small company status is lost, it will not be lost forever. Every year you have to check. Next, small company excludes 5 companies. How many companies? 5 companies. First, public company, subsidiary company, holding company, section 8 company, statutory company. All these 5 companies are excluded from the definition of small company. In one examination paper, I saw the question that, Alpha Foundation got license under section 8. The preceding financial year, the total turnover is 10 crores and paid up share capital is 1 crore. Directors of the company, Alpha Foundation, wants to claim the status of small company so that they can claim a benefit of exemption of cash flow statement. Small companies are not required to prepare cash flow statements, right? So Alpha Foundation want that benefit. Allowed or not allowed? Not allowed, because section 8 companies are excluded from the definition of small company. Clear? Next, subsidiary company. Deemed subsidiary concept is a exceptional point. Subsidiary company, you all know. So one company can control other company in 2 ways. One is control over composition of board of directors, and the second way is having more than half of the total voting power. See, this more than half of the total voting power, this control you can exercise directly, or you can exercise indirectly, or you can exercise partly direct and partly indirect. Say for example, yes, H Limited is having 60% voting power in ES Limited. This is direct subsidiary. ES Limited is having 75% of control in D Limited. For example, D Limited. Now D Limited is also subsidiary to H Limited. This is indirect control. Clear? Next point. Shares held as a trustee or in a fiduciary capacity is not considered for the control. Important exceptional point. Listen carefully. Suppose 2 companies are there, A Limited, B Limited. A Limited acquired 42% of paid up share capital of the B Limited, and it is also acquired some 9% paid up share capital, but not for itself, but as a trustee. Say for example, M, the member of B Limited, holding some 9% paid up share capital, transferred to A Limited, and A Limited will act as a trustee. A Limited is not the beneficial owner. A Limited is just a trustee, or A Limited is holding shares in a fiduciary relationship or fiduciary capacity. Now in this case, 42 plus 9, can I include this 9%, sir? No. 42 plus 9, 42 only. This 9% is not considered. Look at the point. Shares held as a trustee or in a fiduciary capacity, considered or not considered? Not considered for control. Exceptional point. Next one, government company. Subsidiary to government company is also a government company. As you all know, government company means it's a company in which at least 51%, you can see here, at least 51% of paid up share capital was held by CG or SG, one or more state governments. Next, partly by CG and one or more state governments. Correct? See, central government holding some 52% of paid up share capital of IOCL. Now IOCL is a government company. IOCL is having some 50.5% control in C Limited. Now subsidiary to government company is also a government company. So this classification is very important in case of appointment of the auditor. Who appoints auditor to IOC? C&AG. And who can appoint auditor to C Limited? Same C&AG. Subsidiary to government company is also a government company. Remember. Next one, control. If you observe control, 20 to 50% control. If a company is having 20 to 50% control in another company, then another company becomes associate. 20 to 50, both limits are included. 20 to 50. More than 50%, then other company becomes subsidiary. At least 51% of paid up share capital held by the governments, then it is a government company. Clear, everyone? First chapter over. Next, let's continue with second chapter, incorporation of company. Incorporation of company. First one, promoter. Who is a promoter? One who has been named as a promoter in the prospectus or annual returns, or one who is having control over affairs of the company as a member or director or otherwise. These 2 points are normal. But if you look at the third point, a person who provides directions, advice, instructions that the board of directors is accustomed to follow, then this fellow also becomes a promoter. I call him as shadow promoter. Okay, so promoter. But in that point, we had one important exception. Professional rendering services in professional capacity is not considered as a promoter. Professional rendering services in the professional capacity not considered as promoter. If he do something beyond his professional services, capacity, beyond professional capacity, then he might be considered as a promoter. On this, we had one practical question. Let's see. A tricky question. You can see here, Mr. Kaushal is a chartered accountant and MBA by profession. MBA by profession. Has been appointed as an executive director on the board. His job profile includes advising the board of directors of company on various compliance matters, strategies, business plans, and risk matters relating to the company. Keeping in view of the above position, whether Mr. Kaushal can be classified as a promoter. If he is just a chartered accountant, compliance matters, okay, no problem. But business plans, strategies, he might be the promoter. But he is also having another qualification, MBA by profession. MBA by profession. That's why all this comes within his professional capacity only. That's why he will not be considered as a promoter. Getting my point? Next one. Association with initial formation is not mandatory. To call someone as promoter, association at the time of, association with initial formation is not required. Even subsequent involvement in floating the capital or getting the control is sufficient. Next, OPC, one person company. OPC cannot carry three activities. OPC cannot carry out three activities. What are those three activities? Section 8 company, Section 8 activities, that means charitable activities, NBFC activities, investment in body corporate activities. These three are prohibited. These three activities are prohibited. In one attempt, a question came, OPC wants to convert itself into Section 8 company. Possible? Or OPC wants to carry out Section 8 activities. Allowed? Not allowed. Next one. Like OPC, on member and nominee also there are some conditions. The conditions are, member nominee should be natural person, should be citizen of India. That's it, only two conditions. Residential status is not a criteria, whether resident or otherwise. Residential status is not a criteria. Member or nominee need not be resident in India. After becoming a member of two OPCs, a person must exit one within 180 days, since only one OPC membership is allowed at a time. For example, we had two OPC companies, XOPC, YOPC. In XOPC, X is the member, Y is the nominee. In YOPC, Y is the member, X is the nominee. Suppose X died. Now Y became member of XOPC and Y is already member of YOPC. So now he is holding membership in how many companies? Two one-person companies. Permitted up to 180 days permitted. Within 180 days, he should take corrective action. Getting my point? Next one. Whenever there is a vacancy in nominee clause, that means nominee becoming member or member removed nominee, nominee withdrawn the consent. Okay, whenever there is a vacancy in the nominee, appoint a new nominee within 15 days and communicate the same with ROC within 30 days. Change in nominee, section 13, alteration of MOA provisions will not apply. Change in nominee, alteration of MOA provisions will not apply. Next, section 3A, breach of minimum number of members. For a public company, minimum 7 members are required. For a private company, minimum 2 members are required. Suppose accident happened and number of members in the company fallen below the statutory limit. Say for example, 7 members in public company, after accident become only 5. Now, if a company continues business for more than 6 months, that means from the date of reduction, company carried business operations for a period more than 6 months. Any member who knows this and continues during that period, that means after 6 months, becomes personally liable for the debts incurred during that time. So up to the reduction, company responsibility. After reduction of number of members, till expiry of 6 months, company responsibility. But after expiry of 6 months from the date of reduction, company is not responsible for the additional debts or new debts that were contracted after expiry of 6 months. Who is liable? Members. Not all members. Members who are having the knowledge of fact that company is carrying business operations with reduced number of members. Only those members will get unlimited liability, and their nature of liability is joint and several. Same point is there in LLP also. Next one, preservation of incorporation documents. Of course, the company shall maintain and preserve all the copies of all incorporation documents. The company shall maintain and preserve copies of all incorporation documents and information originally filed at its registered office until its liquidation. So simply MOA, AOA, declaration by the professional, declaration by the subscribers and first directors, address for temporary correspondence, interest of the directors in the other body entities, other business entities, details of the subscribers, details of the directors. So whatever information you file with ROC for incorporation of a company, that information should be preserved at registered office till the liquidation of the company, not 8 years, till the liquidation. Next one, Section 8 company. Section 8 company should satisfy 3 conditions. First one, object clause should contain charitable objects, namely, social welfare, science, art, education, environment protection, religion, culture, commerce. Next one, dividends allowed or prohibited? Dividends are prohibited. Then what to do with surplus? Invest surplus in promoting the objects of the company. The biggest advantages of Section 8 company, minimum and maximum number of directors concept, nomination and remuneration committee concepts not applicable. Partnership firm can become member of Section 8 company. And Section 8 company, for calling general meeting, 21 clear days notice is not required. 14 clear days notice is enough. 14 clear days notice. Is it clear? But now the point is, consequences of revocation of Section 8 company license. Whenever Section 8 company violates Section 8 conditions or conditions prescribed by the central government, so violation of these things, central government may revoke the license after giving one opportunity of being heard. After revocation of license, what would be the consequences? The Section 8 company may be wound up under Companies Act or amalgamate with similar Section 8 company. That means Section 8 company with similar objectives. In case of winding up, leftover assets, nothing but surplus after settling all the debts, whatever surplus is there, transfer that money to IBF, Insolvency and Bankruptcy Fund, or similar Section 8 company. Next one, entrenchment of AOA. So we can entrench AOA at the time of formation of the company or subsequently after formation of the company by way of alteration, nothing but amendment. Sir, for amendment, what type of consent I need, sir? If you are a public company, special resolution is required. If you are a private company, consent of all members is required. So this is exceptional point. All members consent in case of private company required to entrench AOA. Next one, disqualifications for change of name. Voluntary change of name, disqualifications. If you have any one of these 6 defaults, sir, what are those 6 defaults? Default in deposits repayment, defaults in debenture repayment, default in payment of interest on deposits, interest on debentures, 4 over. Non-filing of annual returns, non-filing of financial statements. Company is prohibited from changing its name. Clear? Sir, what is the remedy, sir? Pass special resolution. Sorry. Rectify the defaults. First, you rectify the defaults. Upon rectification, immediately you can proceed with change of name. And for change of name, special resolution is required. What type of resolution? Special resolution is required. Clear? Everyone. Next one. Incorporation of company by submitting false information or suppression of material information. Then what would be the consequences? Punishment. Punishment, here punishment is to both company as well as applicant. Punishment to the company as well as applicant. Applicant gets punishment under section 447. Not only applicant, but also the persons whoever submitted the declaration. Declaration of compliance. So everyone will get punishment under section 447. For company, the punishment is NCLT may order for alteration of MOA AOA. NCLT may order for declaring members liability as unlimited, simply lifting of corporate will, removal of name from the register, order for winding up, pass any such necessary orders. But before passing any order, NCLT will give an opportunity of being heard to the company. Tribunal also consider the transactions, obligations, liabilities incurred by the company during that period before passing the order. Next, shifting of registered office. Shifting of registered office is possible in 4 ways. One is within the same city. Second one, change in city, no change in ROC, no change in state. Change in ROC, no change in state, and change in state. For within same city, case 1, board approval is enough, members approval not required. Board approval is required, board approval is enough, and ROC filing. File INC 22 within 30 days of shifting to the new premises. Change in city but no change in ROC, no change in state. Here members approval is required. Board approval to call for general meeting to fix a time, day, place of general meeting, and at that general meeting pass special resolution, and of course ROC filing is required. File INC 22 as well as MGT 14. Copy of special resolution shall be filed in MGT 14 within 30 days of passing the resolution, and INC 22 shall be filed within 30 days of shifting to new premises. Change in ROC but no change in state. Here, in addition to board approval and members approval, you have to take approval from RD, regional director approval. So board resolution, special resolution, RD approval. RD gives approval within 30 days of receiving complete information, and then proceed with filings, ROC filings. So within 60 days of Audits order, communicate with ROC, and within 30 days of shifting to new premises, also communicate with ROC in form INC 22. Change in state. Here CG approval. CG gives, CG already power delegated to whom? RD. Power already delegated to RD. But RD gives approval subject to creditors approval. Subject to whose approval? Creditors approval. Getting my point? So each and every stage one approval is getting added. So board resolution, special resolution, RD gives approval subject to creditors approval. So RD will give approval within 60 days of application, also getting complete information. Next, proceed with ROC filings. So ROC filing should be done within 30 days of RD's order. And again, after shifting to new premises, file with a new ROC INC 22. Clear? For that also time limit is 30 days. Just add creditors approval in this step, ma. Clear? Next, yes, ma. In Section 8 company, one exceptional point is there, ma. To alter MOA of Section 8 company, CG permission is required, power already delegated to RD. To alter AOA, of course CG approval is required, but power already delegated to ROC. This point also remember. Next one, name reservation period. How long name will be reserved, sir? For a proposed company's incorporation, name will be reserved for 20 days. Existing company wants to change its name, then the new name for existing company shall be reserved for 60 days. And if you reserve the name by furnishing false information, company not yet incorporated or company's name not yet modified, not yet altered, then name so reserved shall be cancelled and applicant gets fine up to 1 lakh rupees. Applicant has to pay fine up to 1 lakh rupees. If company was incorporated or name has been changed, then ROC may order change of name and you have to comply the ROC's order within 3 months, or else ROC may strike off your name, ROC may file petition for winding up of the company. Ultravires acts can be ratified or cannot be ratified? Cannot be ratified even with unanimous consent of shareholders. Ultravires acts are void ab initio, so neither party can enforce it. Neither party can claim damages. Any member holding single share can bring an injunction order to stop the company from doing an Ultravires act. Next one, Section 10A, commencement of business. Company having share capital, I repeat, company having share capital cannot start business, cannot start exercising borrowing powers until they comply with two provisions. One is filing INC 22, that is verification of registered office, which should be done within 30 days of incorporation. And next one, INC 20A, that is commencement of business, it should be filed within 180 days of incorporation, stating that subscribers to the MOA have paid agreed value of the shares they subscribed to. That is the point. After complying these two conditions, company can start business, company can exercise borrowing powers. Next one, rectification of name. Section 16. Whenever a company name is identical to or similar to an existing company, or in case of infringement of trademark, the registered trademark owner has to file an application within 3 years of incorporation of the company or within 3 years of change of name by the existing company. What is the time limit? 3 years. Not less, not more. 3 years. Change name within 3 months by passing ordinary resolution. The moment you get CG order, within 3 months, comply with CG order. That means within 3 months, change the name. Once ordinary resolution is passed, communicate with ROC within 15 days. ROC issues fresh certificate of incorporation. Failure to do so, CG will fix one new name to you. Of course, you can change that new name by complying with section 13. An important point, whenever you change the name, along with new name, former name should be displayed for a period minimum 2 years. That means last 2 years, whenever you have changed the name, you have to disclose new name as well as old name, nothing but former name. Copies of MOA, AOA, etc. to be given to the members. Here, request by member alone is not enough, he need to pay sufficient fees. Then only company had duty to serve requested documents in how many days? 7 working days. 7 working days. So, two exceptional points. One is payment of fees. Don't forget payment of fees. Second one, company's duty to submit those documents within how many working days? 7 working days. Exceptions to doctrine of indoor management. If an outsider knows of an irregularity, that means knowledge of irregularity, outsider could easily discover the irregularities, that means negligence and forgery. And when there is a doubt about existence of an agency, when there is a doubt between the director and the company, whether the director is having powers to do or not. When a precondition must be met before company can exercise certain powers, in all these cases indoor management is not applicable. Simply you can also think like this. These are the cases where doctrine of constructive notice is applicable. Doctrine of constructive notice is applicable. Is it clear? Next one, section 19. No company to hold shares in its holding company, but we had 3 exceptions. As a legal representative, you can continue to hold the shares. Trustee, as a trustee, you are allowed, and you acquired shares before becoming subsidiary. Now you can retain those shares. But important point is, voting is allowed in only first 2 cases. Voting is allowed only in 2 cases. That is, if you are a legal representative of a deceased member, or if you are a trustee for others. In these 2 cases, voting rights are allowed. But for the shares you acquired before becoming subsidiary, voting is not allowed. Next one, section 20, Nidhi company, section 20, service of documents. In that Nidhi company, members are classified into 2 categories, big members or small members. There is no such words big or small, but for easy understanding I am telling you. Big members means who? Members holding more than 1000 rupees face value of securities, equity share capital, or more than 1% of the paid up share capital. Anyone satisfied, that member is known as big member. To the big member, serve documents individually. Go to that person, hand over the documents individually, physically. Whereas small members, other shareholders, other small shareholders, other nothing but small shareholders, service by public notice. Advertise in newspaper and make it available in the notice board. Allow them for inspection. That's it. Small members, no need of individual notices. Just advertisement enough. Big members give individual notices. That's it, Authentication of documents, deeds. Negotiable instruments can be accepted by a person either with implied authority, or he should get an authority in writing. It should be signed by 2 directors. In case company is having secretary, then 1 director and 1 CS should authorize the person to sign the documents, deeds on behalf of the company. Next one, subscription to MOA. If a subscriber is illiterate, thumb impression. Along with that, a writer or reader who explained the terms and who made that illiterate subscriber to subscribe MOA, that fellow should also sign the document. Body corporate subscriber, authorized signatory is required. LLP as subscriber, authorized partner. Foreign national, non-resident, notarization is required if that fellow notarization is enough. But if that fellow belongs to a country which is not a part of Hague Apostille Convention, then authentication by diplomatic or consular officer is also required. Simply embassy. Foreign national, resident in India. Foreign national, this is non-resident, this is resident. So visa requirement, business visa, submit business visa. But business visa is also not applicable to the persons who are from Indian origin. Person from Indian origin or overseas citizen of India. For them, business visa required or not required? Not required. So with this second chapter also completed. But if you go through these my handwritten notes, any other points, any uncovered important points, let's see. In OPC, residential status is not a criteria, but to check whether he is resident or not, period of stay at least 120 days in the preceding financial year is enough. So all these points I explained. Yes. So conversion of Section 8 company, just give one time reading, enough. Yes, So alteration to be noted. That point is also a normal point only, not tricky point. Time limits you can see here. RD order, filing RD order with ROC certificate. Clear? Fine. Alteration to be noted in every copy, or else company officer in default will get a punishment, 1000 per copy issued without such alteration. Fine, Next, let's continue with the next chapter, prospectus. In prospectus, securities excludes unit linked insurance policy. Remember, the definition securities excludes, not includes, excludes unit linked insurance policy. Unit linked insurance policy is not a security. Listed company identification, very, 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 very important. Generally, any of its securities listed on any recognized stock exchange, then company is known as listed company. But following 3 companies are not listed companies. Which 3 companies? Let's see. Public company that have not listed their equity shares. That means equity shares unlisted ma. Equity shares unlisted. But what listed? NCD and non-convertible redeemable preference shares. Both must be issued on private placement basis only. Not public offer, private placement only. See, equity shares unlisted, NCD issued on private placement basis, or NCRPS issued on private placement basis, or both the categories. Then also public company is unlisted company only. For private company, only NCD. Preference option is not there. Non-convertible securities issued on private placement basis, even though listed on recognized stock exchange, it remains unlisted only. Foreign listings, public company that have not listed equity shares on Indian stock exchanges, but whose equity shares are listed in foreign jurisdiction, then also that company is not a listed company. Clear? Foreign listings also unlisted only. I mean, in India, since equity shares are not listed and just equity shares are listed outside India, unlisted only. Why? Because listed company issue and transfer of securities, non-payment of declared dividend, who will govern these matters? SEBI will govern these matters. Next one, prospectus. Tell me when prospectus is required. Prospectus is required not only for IPO but also for FPO, also for OFS. But prospectus is not applicable in the following two cases: when offer is given to the existing members, or offered securities are uniform in all aspects, all respects with previously issue and they are already listed on stock exchanges. Previously I offered 1 crore shares to the public. I got subscription for 98 lakhs. And these were already listed on recognized stock exchange. Balance 2 lakh shares. That means existing shares. If I am offering existing shares or if I am offering the securities to the existing members, both the cases prospectus not required. Next one, rights issue is deemed to be prospectus if renunciation leads to offer exceeding 50%, more than 50%. Mere labeling as private circulation does not prevent it from being a prospectus if it is inviting the public. So on the title, the title of the document, strictly private, strictly confidential, that doesn't mean it is not a prospectus. That doesn't mean it is not a prospectus. You need to look at the purpose. If the purpose is inviting offers from the public to purchase or subscribe securities, then it becomes a prospectus. Expert statement, if you want to include expert statement in the prospectus, these three conditions to be satisfied. Expert should be independent. That means he should not be connected to the promotion, incorporation or management of the company. The expert provides a written consent, and such consent should not be withdrawn before filing with ROC. And the same shall be disclosed. Same shall be disclosed in the prospectus. Clear? Next one, prospectus generally have a validity period of 90 days. How many days? 90 days of filing with ROC. Once you file a prospectus with ROC, the prospectus will have a validity period of 90 days. That's it. Next, deemed prospectus. Deemed prospectus. First of all, if the offer is deemed to be public offer, then the document you are issuing to the public is deemed to be the prospectus. So here, involvement of third party is required. Company C Limited allot shares to issue house with a view to offer those shares to public. Now, whenever issue house is making an offer to the public, it is not deemed to be public offer. It will be deemed to be public offer when such offer is made within 6 months from the date of allotment by C Limited or agree to allot, or full consideration for securities has not been received. Suppose full consideration of the securities is 100 crores. Issue house, if it keep 1 rupee pending, 1 rupee pending also, that means whole consideration has been discharged or has not been received? Has not been received. 1 rupee outstanding should be not there. Should not be there. 1 rupee outstanding also should not be there. Okay, na? Then only it is not deemed to be public offer. Tell me when it is not deemed to be public offer. Offer should be made after 6 months and whole consideration has been discharged. Quite opposite. That means if offer is made within 6 months or full consideration has not been received by the company, both the cases, offer to the public is deemed to be public offer and the document is known as deemed prospectus. Interesting point. Who signs deemed prospectus? Issue house. If issue house is a company, 2 directors shall sign the deemed prospectus. If issue house is a partnership firm or LLP, at least half of the partners in the firm should sign deemed prospectus. Next one, variation in the prospectus terms. For variation of terms in the prospectus, special resolution is required and that special resolution shall be passed through postal ballot. First, publish the notice along with explanatory statement in 2 newspapers. Also publish it on company's website. Funds you collected by issuing prospectus can be used for any purpose, after approval of the members, but you cannot use it for carrying speculation activities. Speculation in the equity shares of other listed companies strictly prohibited. Promoters or controlling shareholders shall give exit option to the dissenting shareholders. Who should give exit option to the dissenting shareholders? Option A, company. Option B, promoters. Next one, shelf prospectus. Shelf prospectus will have a validity of 1 year from the date of first public offer under the shelf prospectus. But for subsequent public offers under the shelf prospectus, you have to prepare a document called information memorandum, which must be filed with ROC 1 month prior to subsequent public offer. 1 month prior to subsequent public offer, 1 month prior only you have to file a copy with ROC. And any applicant who deposited money in advance, if he decides to withdraw after going through information memorandum, refund should be made within 15 days of availing the option. And company is not eligible to deduct administrative charges while refunding the money to the applicants. No deduction, 100% refund. Red herring prospectus must be filed at least how many days before opening of subscription list? 3 days. Remember the time limit. At least 3 days before opening of subscription list, red herring prospectus shall be filed with ROC. Variations must be specifically highlighted. Differences between red herring prospectus and final prospectus shall be highlighted. Clear? In examination, they may ask you question like this. Company is not sure with respect to issue price, and company wants to know the price from market forces, namely demand and supply. So advise the company what type of prospectus company can issue. Red herring prospectus. Suppose company want to make more than one public offer under one prospectus. Advise the company which prospectus is suitable. Shelf prospectus. Next one, OFS, members selling the shares, that means we call them as selling shareholders, shall authorize the company to act on their behalf for carrying out the transaction, and they should reimburse the company any related expenses, expenses in connection with issue. Who should bear expenses? Issue expenses? Company? No, selling shareholders. Next one, misstatements in the prospectus. The effect of misstatements in the prospectus, yes, criminal liability. Person gets punishment under section 447, but you can take any one of the following defenses. One is prove that statement or omission was immaterial, or prove that you had reasonable grounds to believe the statement was true. Civil liability, person has to compensate the investors, suffered investors. But criminal liability is applicable whenever there is a misstatement. Civil liability is applicable whenever there is a misstatement, as well as loss to the public, loss to the investors who invested their monies on the faith of the prospectus, and they should be allottees, they should be direct purchasers, not subsequent purchasers. Okay, na? Suppose if there is a misstatement and there is a loss also, then which sections are applicable? Both criminal and civil liability applicable. Both criminal liability and civil liability. Sir, no loss to the investors, sir. Then only criminal liability is applicable for misstatements in the prospectus. But civil liability, you can take any one of the following defense. Either withdraw the consent before filing with ROC, or give public notice that your name was included without your permission, or tell that you acted on expert statement believing it to be true. In examination, 2 times I think question came like this. Directors on the faith of promoter, not professional, on the faith of promoters gave consent to the prospectus. Can they take any defense? No. Faith should be on expert, independent person, not promoter. Clear? Next one, misstatement cases, false subscription claim. We got 80% subscription from promoters. Actually, it is 8%, but we are giving a wrong information. Is it misstatement? Yes. Half truths are also misstatements only. Ambiguous statements, true in one sense, but misleading in reality, that is also misleading. And because of misstatements, person can, investor can cancel the contract, can claim back their investment amounts. But subsequent purchasers, the person who purchased the shares from the existing members in the stock market, in the open market, subsequent purchasers cannot seek rescission, and subscribers to MOA also cannot seek the rescission. Remember these 2 points, subsequent purchasers, subscribers cannot cancel the contract because of misstatements in the prospectus. Next one, allotment of securities. All money received on applications for securities shall be kept in a separate bank account, and allotment is allowed on satisfaction of 3 conditions. What 3 conditions? First condition, minimum subscription, which should not be less than 90% of the public offer. Minimum subscription means amount stated as minimum subscription in the prospectus, but it should not be less than 90% of the public offer. Second, minimum application money, 5% of the face value as per Companies Act. 25% of the issue price as per the SEBI. And third condition is listing. So with which stock exchanges you file an application. From all those stock exchanges you need to get permission, listing permission. Any one stock exchange rejected your application, you are not permitted to make allotment. And upon satisfaction of minimum subscription and minimum application conditions, you can make allotment of securities. But if these conditions are not satisfied, then within 15 days of issue closure, offer closure, simply within 15 days of issue closure, refund those monies, or else board of directors have to pay interest, not company, board of directors. What is the rate of interest? 15% per annum. 15% per annum. Is it clear? Next one, underwriting commission. Remember commission is not applicable, or no commission payable on the securities not offered to the public. So that means if promoters are taking any shares, on those shares underwriting commission applicable or not applicable? Not applicable. Commission will not be paid on the securities which were not offered to the public. Underwriting rate of commission, commission rate 5% in case of shares, 2.5% in case of debentures, or AOA, whichever is lower. And of course underwriting commission can be paid in cash or can be paid in kind. And sources of underwriting commission, profits. Next one, issue proceeds, or both. AOA permission is required AOA authorization is required for payment of underwriting commission. Of course, when I am telling AOA whichever is lower, AOA express permission is required. Next one, private placement. In private placement, count 200 important. This 200 is per financial year, not lifetime of the company, per financial year. And limit applies separately to each type of the security. Equity 200, preference 200, debentures also 200. Exclusions, while counting 200, QIBs and ESOPs are included or excluded? Excluded. And these limits are not applicable to NBFC and housing finance companies. They will follow their regulatory limits. Allotment shall be made within 60 days or else refund within the next 15 days. If not refunded within the next 15 days, interest will be added. Company will pay interest. How much is the rate of interest? 12% per annum. And this interest is not only for delay period, but from 61st day onwards. 61 to 75. These 15 days also company has to pay interest. And the next delay period also company has to pay the interest. Clear? Suppose, sir, company made allotment, sir. Company made allotment. Then within 15 days of allotment, file return of allotment with ROC. File return of allotment with ROC within 15 days. Is it clear? For prospectus for public offer, return of allotment should be filed within 30 days. Here, return of allotment should be filed within 15 days. Getting my point? Students, everyone. Prohibition in private placement, public advertisement, media channels advertisement not allowed. Private placement offer and application shall not carry any benefit of renunciation. Companies cannot make fresh private placement keeping previous private placement pending. This is also exceptional point. Any previous private placement, if it is kept pending, that means allotment not completed or it has not been withdrawn. In that case, can a company make fresh private placement? No. Even if it is a different security also. Previously debenture, now equity share. Allowed or not allowed? Next point, voting rights. Holders of global depository receipts can become a member of the company and vote only after converting GDRs into the underlying shares. Until then, who will vote? Overseas depository shall vote on behalf of GDR holders. So GDR holders can exercise voting power only when the depository receipts got converted into equity shares. Clear? With this, prospectus exceptional topics over, but let's see any important point in the handwritten notes. Advertisement of prospectus. If company decides to advertise the prospectus, then contents of advertisement should be clauses of MOA plus capital structure. Object clause, liability clause, signatories to MOA, capital. That means share subscribed by the signatories. Everything you have to mention. That's why contents of MOA plus capital structure. Next, 36, 38. Two sections are there, 36, 38. 36. Punishment for fraudulently inducing person to invest money will get punishment under section 447. 447. So here you can see acquiring, disposing, subscribing, underwriting securities, secure profit from yield of securities, fluctuations in securities value, or obtaining credit facilities from any bank by submitting fraudulent information. People get punishment under section 447. And section 38, Personation for acquisition of securities. Personation for acquisition of securities. Filing application in a fictitious name or multiple applications in different combination of your name induces company to allot or register any transfers in the name of fictitious person, then person gets punishment under section 447. Of course, this provision should be disclosed in the prospectus. In case of conviction, any person violating section 38, disgorgement of gains and seizure of securities, all the amount shall be transferred to IEPF. 447, punishment for fraud. If public interest is affected, fine minimum amount involved in the fraud, maximum 3 times of the amount involved in the fraud. End, not or. End. Imprisonment, minimum 3 years, maximum 10 years. Sir, no public interest, sir. Then you have to check fraud, greater magnitude fraud or lesser magnitude fraud. Greater magnitude fraud, no public interest, same punishment, but imprisonment it's not 3 years. Imprisonment is 6 months, sir. Smaller magnitude, sir. Sir, smaller, bigger, how to know? Amount involved in the fraud, compare with 10 lakhs or 1% of the turnover, whichever is lower. If it is greater than or equal to, greater magnitude, less than, not less than or equal to, less than, then it is smaller magnitude, fine up to 50 lakhs, imprisonment up to 5 years or both. All these conditions already covered, all these points I covered. So with this, now prospectus chapter is also over. Next one. Share capital and debentures. Here you have to remember one small concept: shares versus stock. Shares versus stock. Company can directly issue shares, but company cannot directly issue stock. Shares can be fully paid up or shares can be partly paid up, but stock should be fully paid up. Only fully paid up shares can be converted into stock. Stock comes into the picture by conversion of shares. By converting shares, stock comes into the picture. Getting my point? Company cannot directly issue stock. Company cannot convert partly paid up shares into the stock. Remember these 2 points, because definition of share means share in the share capital of the company and includes stock. Clear? Okay. Now equity shares with differential rights. You have to remember default MOA. What is the conditions? What is the conditions for issuing equity shares with differential rights? Default MOA. And order starts reverse. A, AOA authorization. O, ordinary resolution. Ordinary resolution. If your company's equity shares were listed on recognized stock exchange, then ordinary resolution shall be passed through postal ballot. Through postal ballot. Next one, M, maximum limit, maximum voting power from the differential rights. That means the voting power from the differential rights shall not exceed 74% of total voting power of the company. Now coming to the defaults, 3 types of defaults you can see here. One is subsisting defaults, one is last 3 years there should be no defaults. Next one, 5 years defaults, post rectification, wait for 5 years. When it got rectified, ignore that year, also ignore 5 years. Next year you can issue equity shares with the differential rates. Sir, what are those defaults, sir? Deposits repayment, debentures repayment, interest on deposits payment, interest on debentures payment, preference shares and dividends. If you have these defaults, rectify them, then only you can issue equity shares with differential rights. Last 3 years, company should not have committed default of filing annual returns, filing financial statements. Not penalized under SEBI Act, FEMA Act, RBI Act, SCRAW, Securities Regulation, Contract Act. Next one, 5 years, term loan repayment, interest on term loans. Payment of preference dividends, payment of employee statutory dues, transfers to IEPF. Here, default year is not criteria. Rectification, when you rectified, rectification year, add 5 years. Then next year onwards, company can proceed with issue of equity shares with differential rights. And exceptional point, differential right members will get bonus shares that are also differential. Differential right holders will get rights shares that are also differential in nature only. Fraudulent issue of duplicate share certificate. In case of fraudulent issue of duplicate share certificate, punishment to the company minimum 5 times or maximum 10 times or 10 crores, 10 times of the face value of shares so duplicated, or 10 crores, whichever is higher. Minimum 5 times, but maximum 2 limits are there: 10 crores or 10 times, whichever is higher. Officer in default will get punishment under section 447. Next, voting rights. If preference dividends remain unpaid for 2 consecutive years, then preference shareholders will also get voting rights on all resolution like equity shareholders. For quorum also we can count them if preference shareholders are getting a voting power. A member of Nidhi company can exercise maximum voting power of 5%. Remember this point. In Nidhi company, concentration of voting power is eliminated by putting a restriction. What is the restriction? If you have more than 5% of the paid up share capital of Nidhi company, can you exercise complete voting rights? No, your voting rights are limited to 5% only. Are you limited to 5% only? Next one, variation of the rights. If variation affects rights of another class, consent of 3/4 of that other class is also required. You all know for variation you have to check MOA, AOA. If MOA, AOA is silent, go through issue terms, there should be no prohibition. Then get consent. What type of consent? Special resolution at meeting. No sir, postal ballot is applicable to us sir. Then consent from 3/4 of the value of capital, 3/4 of class capital value members. Not, the limit is not on members, the limit is on class of capital value of the capital. So 3/4 in value consent is required. If variation of one class affects the rights of other class, you have to obtain similar consent from other class also. Next one, dissenting shareholders not less than 10% of class capital can file a petition with NCLT within 21 days. 10% to 21 days. NCLT will decide. Now company has to file NCLT order with ROC within 30 days. So that's it. Complete section I discussed with you. Next one suppose yes, students had a doubt, sir, what if these shares are non-cumulative? Cumulative or non-cumulative are not a matter. Cumulative or non-cumulative not a matter. 2 years preference shareholders are not getting dividends, they get voting rights. Calls in advance, company can accept calls in advance only if it is authorized by AOA. And advance payments is a liability to the company, it's not a capital, so no extra voting. Sir, what about dividends sir? Dividends depends on section 51 51. If AOA is silent, dividends will be paid on face value. That means all will get dividends, whether it is a partly paid up or fully paid up. But if AOA authorizes company to pay dividend only on paid up value, then no dividends for calls in advance. Next one 52. Last attempt 52, section 52 tested utilization of securities premium, B square E P square, buyback bonus issue related expenses in connection with issue, P square, premium on redemption of securities, preliminary expenses. But if you are a company complying section 133, that means preparation of financial statements in accordance with AS, then P square is not allowed. Buyback bonus issue, expenses in connection with issue, that's it. Next one, sweat equity share limits sweat equity shares. Special resolution is required, and this special resolution is valid for a period of 12 months. That means within 12 months of SR issue to be completed. New class of shares cannot be offered as sweat equity, only existing class of shares, and that to lock-in period how many years? 3 years. Sweat equity issuance is limited to 15% of paid up equity share capital in a year or 5 crores, whichever is higher. But during the lifetime of the company, sweat equity component shall not exceed 25% of paid up equity share capital. For startup companies, private limited companies, only private companies get startup status if authorized by DPIT. If specially permitted by DPIT, then only these companies get the status of startups, private company with DPIT certificate. So they can have sweat equity component up to 50% of paid up share capital, that too up to how many years? 10 years, up to 10 years of incorporation. Next one, companies engaged in infra projects, section 55, companies engaged in infra projects. So preference shares validity, preference shares can be up to 30 years, the tenure of preference shares can be up to 30 years. You all know AO authorization is compulsory, no subsisting default with respect to existing preference shareholders. Next one, special resolution is required. Next one, irredeemable, possible or not possible, tenure 20, but infra companies 30 years. Provided 21st year onwards, every year 10% redemption should be done. This is with respect to tenure. And of course, for redemption also we had conditions. For redemption, AOA authorization not at all required, but shares should be fully paid up. Shares should be fully paid up. For redemption, important condition, shares should be fully paid up. Next, redemption value includes two components, face value premium on redemption. For face value, you can utilize company profits or you can utilize issue proceeds. If you are utilizing company profits, create CRR. Next one, premium on redemption. Yes, you can utilize company profits. And if you are not required to comply section 133, that means for you AS is not applicable, then you can also utilize securities premium for premium on redemption of securities. But in this, another important highlight point is deemed redemption of preference shares, deemed redemption. This is not actual redemption, deemed redemption. For deemed redemption, 3 conditions to be satisfied. First, NCLT approval. NCLT will give approval upon satisfaction of 2 more conditions. One is consent from 3/4 in value of preference share capital, and NCLT give permission only when the dissenting shareholders were completely paid off. Now, when you are issuing preference shares to redeem existing preference shares, you can also issue preference shares not only for face value but also for dividends in arrears. For dividends in arrears also shares will be given. And there is no assumption of increase or decrease of share capital. That means alteration of share capital, that those points are not applicable. Next one, Next one. Registration of transfer of partly paid shares without notice to the transferee. But before that, issue of shares at discount, allowed or not allowed? Issue of shares at discount, allowed or not allowed? Not allowed, but it had 2 exceptions. One is sweat equity, just now we finished. Other one is SRP DRS, statutory resolution plan, debt restructuring scheme. Simply remember about your internal reconstruction. So creditors agreed to waive off some balances. For remaining balance, company is issuing shares at a discount price. Allowed or not allowed? Allowed. Next one, section 56, registration of transfer of partly paid up shares. When an application is executed by transferor alone and shares involved are partly paid up, company shall not register the transfer unless it gives intimation to the transferee and wait for 2 weeks. Without notice to the transferee, that means transferee has to respond within 2 weeks, or else company can assume that transferee had no objection. Legal representative of the deceased member, either he can register himself as a member or he can transfer shares without becoming a member. Both are allowed. Transfer happens voluntarily. Transmission, operation of law. Member got deceased, member became insolvent, and holding company, when it is into the liquidation phase, the shares it is holding in the subsidiary company, for example, automatically transmitted by operation of law. Next one, differences you all know. For transfer, consideration is required. Transmission, no consideration. Stamp duty is required in case of transfer, not required in case of transmission. Clear? Transfer deed is required for transfer, not required for transmission. Small concepts only. Forged transfer, here 2 parties, original member OM, company C Limited, innocent buyer. That means from original member, fraudulent member obtained shares by way of forgery. Later he transferred to innocent buyer. Now what are the rights of original member? He can compel company to restore his name back. And company C Limited is liable to compensate innocent buyer whatever loss caused to the C Limited because of fraudulent member who created forgery, who is the initiator of the forgery. So that fellow is liable to indemnify C Limited. Next one, ESOPS. But before that, yes, a little small points I'll cover in handwritten notes, don't worry. ESOPS. For ESOPS, generally special resolution is required. But if you are a non-defaulting private company, not defaulting means regular in filing annual returns, regular in filing financial statements, and if you are an IFSC company, for you OR is enough, SR not required for you. Rights issue, dispatch of notices at least 3 days before offer period. 3 days before offer period you have to dispatch the notices. Offer period should be minimum 7 days, maximum 30 days. Of course you can reduce this duration if you are a private company, if you are a IFSC company with the consent of 90% of the members. With the consent of 90% of the members you can reduce this dates 3 days to 7 days. Section 62, that means passing special resolution. Whenever you are offering securities to the other than members, special resolution is required, but SR is not required in the following cases. If a debenture or loan is converted into equity shares, it increases the subscribed capital of a company. However, section 62 does not apply if the conversion terms and conditions are predefined. Convertible debentures, say for example, they are approved in the general meeting through a special resolution before debenture is issued or loan is granted. So already you have taken special resolution at the time of issue of convertible debentures. Now at the time of conversion, and for this purpose issuing equity shares, one more time special resolution required or not required. And CG directed conversion. You know, debentures issued to the central government, loans granted by the government. If company is not in a position to repay these loans, government will consider the company's present situation, public interest, financial interest. Considering all these factors, government may order to convert loans into the equity. Important highlight: if company's authorized share capital is not sufficient to increase this capital, government order itself is enough to increase authorized share capital. Central government order itself is enough to increase authorized share capital. Here section 61 is not applicable. What is section 61? Alteration of share capital. For alteration of share capital, what type of resolution is enough? OR. First check AOA permission, next OR is enough. 5 types of alteration you can see: increase in capital, decrease in capital, consolidation and division, split. Next one, conversion of shares into stock, reconversion of stock into shares. Any alteration you have to communicate with ROC within 30 days. Next one, bonus shares. For bonus shares, sources: CRR, securities premium, free reserves. So revaluation reserves can be used or cannot be used? Cannot be used. Revaluation reserves cannot be used. Bonus shares do not amount to the dividends. Bonus shares cannot be issued in lieu of the dividends. And company must not have following defaults at the time of issue of bonus shares. What are these defaults? Deposits, debentures, both principal as well as interest. And employees related statutory dues. These defaults should not be there. And of course, board resolution and ordinary resolution is required. OR is enough for issuing bonus shares. Next one, prohibition on purchase of own shares. Simply, you know, this is a restriction, restriction on purchase of own shares. A public company cannot provide any financial assistance to anyone for purchasing its own shares or shares of its holding company, but we had 3 exceptions. Important: lending businesses, these rules are not applicable. Employee share purchase scheme, here the purchase value shall not exceed 5% of company paid up share capital plus free reserves. And listed companies valuation, what is the value of the share? You can go through the stock exchanges prices. Unlisted company valuation should be done by registered valuer. So these are the conditions for employee share purchase scheme. Employee loan, first of all, employee should not be KMP, employee should not be the director. Maximum finance, 6 months salary. What is the maximum finance? 6 months salary. Purchase or subscription must be fully paid up shares. If loan exceeds 6 months salary, or with that money if he is acquiring partly paid up shares, then this benefit will not come, this exception will not come. General rule is applicable. Next one, conditions for buyback. So here, you know, amount in the buyback, if it is up to 10% of equity plus free reserves plus securities premium, board resolution is enough. More than 10 but up to 25% only, special resolution is enough. That means maximum amount involved in the buyback is 25% of capital plus free reserves plus securities premium. So post buyback, debt equity ratio should not exceed 2:1. And coming to the number of shares, maximum in a year you can buy back number of shares 25% of the paid up equity share capital. Amount different to number different. Amount means investment amount into the buyback. Number of shares that you can buy, you can make buyback. And you know, in redemption of preference shares also I told you, in buyback also I'm telling, only fully paid up shares can be bought back. Even in bonus shares also, company issuing bonus shares should be fully paid up, and the persons receiving bonus shares must hold shares which should be fully paid up. Bonus issue, fully paid up. Buyback, fully paid up. Redemption of preference shares also fully paid up. Lock-in period, once buyback is completed, next to 1 year buyback is not allowed. Next, cooling period, once you make buyback, the securities involved in the buyback, the class capital should not be offered once again within next 6 months. Even rights issue also not permitted. However, bonus issue, conversion of preference shares into equity, conversion of debentures into equity, existing obligations like sweat equity, ESOPS. So for this you can utilize them. Even within 6 months from the completion of buyback. Next, disqualification of debenture trustee. Important, debenture trustee. Beneficiary Registered member is eligible, but if he is also having beneficial interest, disqualified to act as a trustee. Next one, KDP, KMP, Director, Promoter, EO, Employee Officer of Cash, Company, Associate, Subsidiary, Holding, disqualified. A relative of any promoter, director or KMP of company. KDP relative, only companies KDP relative, not associate, subsidiary, holding. KDP is relative also disqualified. Beneficiary entitled to receive the payments, nothing but creditor, but except debenture trustee remuneration. You are entitled to receive remuneration, not disqualified, except this amount. Any amounts if you are entitled to receive, you are disqualified. And debtor to the 5 companies, debtor to the company, associate company, subsidiary company, holding company, subsidiary of holding company also disqualified. Anyone who has furnished a guarantee, surety also disqualified. And person having pecuniary relationship with the company also disqualified. That relationship should not be there in the current financial year. That relationship should not be there in the 2 immediately preceding financial years also. 2 years preceding and current financial year, yes, disqualified. So let's see my handwritten notes. Any other points, any minute points, I'll show you. Yes, these time limits go through once ma. In recent examinations, if you observe, 20 plus marks are coming with respect to limits, statutory limits. So don't take choice. Subscriber to MOA should get share certificate within 2 months, allottee 2 months, transfer of securities 1 month, transmission of securities 1 month, allotment of debenture 6 months, IFSC companies, all cases 60 days of the event. Punishment for personation, any person to get the benefit associated with the security or any interest, if he is trying to do, or simply if he is personating himself as a member of the company, that fellow gets this punishment, 1 to 3 years imprisonment, 1 lakh to 5 lakhs fine. Next one ma, refusal of registration and appeal against refusal. So company should give notice of refusal within 30 days to the parties involved. Aggrieved party can appeal to the NCLT within how many days? Within 30 days of receipt of notice of refusal. In case of private company, no notice received sir, then 60 days of delivery. Public company, 60 days of receipt of refusal notice or no notice, then 90 days of delivery of documents to the company for registration. So NCLT may dismiss the application or may pass an order ordering the company to correct it, to process the registration within 10 days. Rectification of the registers, yes, your name wrongly entered or your name wrongly omitted, or company committing some unnecessary delay in recording your names, then file a petition with NCLT. Here there is no time limit at all. NCLT may dismiss the application or order the company to rectify the registers. 61 also I covered. 62, yes, I covered all these points. Valuation report is required for non-cash consideration. Once board recommending a bonus issue, once decision is made, subsequently it can't be withdrawn. Fully paid up shares also I told you. SH7 to be filed within 30 days. This is applicable in 3 cases more: alteration of capital, redemption of preference share capital, and government order effect of increasing authorized share capital. So these 3 cases, in these 3 cases, file SH7 with ROC within 30 days. Reduction of share capital So here what happens? Company may cancel unrepresented capital, or company may return back unwanted capital, or company may cancel uncalled capital. Or unrepresented capital, or pay off excess amounts, and unwanted capital may be cancelled. So in these cases, file an application with NCLT, submit all these documents. Once NCLT receives no objection, if there is no objection from these parties within 3 months of receiving the notice, NCLT will go through creditors. If creditors are happy, then NCLT will give permission for reduction of the capital. Any concealment of the name of the creditors, if there is any default in repayment to the creditors, then the officer involved will get punishment under section 447. Persons who were members at the time of reduction of capital will get their original liability. What would be the original liability? That liability will be continued. 67 ma, not applicable cases you have to see ma, not applicable. Private company, it is a private company in which no other body corporate is a member. No body corporate is a member. Borrowings less than twice of the paid up share capital or 50 crores whichever is less, and there is no subsisting default in above borrowings, then such private companies, to such private companies section 67 are not applicable. 68 everything I covered. 69, you know, CRR small point you all know. So if you are making buyback out of company profits, company amounts, company profits, then CRR shall be created. Next, prohibition of buyback ma, this is one more important area. So that's why I'm going through the material once again. There is exceptional topics PDF, okay, but these are like second level exceptional points, important, exceptional as well as expected. You know, if company is having a defaults of deposits repayment, interest on deposits, debentures, preference share capital redemption, term loan repayment, interest on term loan payment with banks or financial institutions, and any dividends, equity or preference dividends, up to 3 years of rectification, buyback is prohibited. Up to 3 years of rectification. And company should be regular in complying with 92, 123, 127 and 129. So in case of debentures, if company want to issue convertible debentures, SR is required. Non-convertible debentures within the limits, board resolution. Within the limits of, you know, borrowing powers, 100% of paid up share capital plus free reserves plus premium. Then board resolution is enough, or else special resolution. Debentures shall not carry voting rights. If company wants to issue debentures with voting rights, void. Such issue is void. Redemption period is 10 years. But for infra companies, infra finance companies, infra debt fund companies, permission is up to 30 years. Tenure is up to 30 years. Charge may be created on company assets holding a company, subsidiary company, associate company, as well as directors' properties also, personal properties also. Market value of the charged assets, yes ma, important point ma. Market value of the charged assets should be at least, it should cover not only principal component but also interest component. So both debenture principal amount and interest component shall be covered by the market value of the charged assets. Then only secured debentures. Trust deed should be executed within 60 days of the allotment. DRR, debenture redemption reserve. Only for non-convertible portion, not for convertible portion. Only for non-convertible portion. That too, how much percentage? 10% of the outstanding debentures. Create DRR. Create DRR that is applicable only for unlisted companies other than banks or financial institutions. And you know, you have to deposit in highly liquid assets ma. How much? 15% of the debentures maturing in the financial year and as well as following financial year. Okay na? Yes, deposit in liquid assets. DRR shall be created out of divisible profits used for redemption of debentures only. Trustee when required, debenture trustee, offer is made to the public or members exceeding 500. Both the cases trustee is required, disqualifications I covered. Liability of debenture trustee can be eliminated only with the consent of 3/4 in value of the debentures. 3/4 in value of the debentures consent. Debentures value. Next one, pay interest, redeem debentures as usual. That's it ma. Share capital chapter also over. Let's continue with the next chapter, deposits. First one, exempted deposits. So following amounts are not treated as deposits, simply exempted deposits. You know, amounts from government, foreign sources, financial institutions, banks, AIF, REIT, IIT, venture capital funds and mutual funds. Intercompany deposits. All these are exempted deposits. Amounts received through issue of commercial papers. Next, application money pending for allotment. If allotment is done within 60 days, not a deposit. If not, refund in next 15 days. If not, refund in next 15 days, then also not deposit. If not refunded, suppose if not refunded, then it is a deposit. Getting my point? If allotment is not done, refund in next 15 days. Secured debentures, convertible debentures, listed debentures, not a deposit. Startup companies raising money by issuing convertible notes where conversion or repayment happens within 10 years and receiving amount under a single tranche of at least 25 lakhs, then also not a deposit. Amount received by Nidhi company, chit fund company, trust, non-interest bearing amounts, collective investment schemes, not a deposit. Amount from the following persons: employees up to 12 months salary, plus non-interest bearing deposit. Company should not pay any interest on that security deposit, then it is exempted deposit. Loan from the directors of public company, loan from the directors of a private company, as well as loan from the relative of a director of a private company, also treated as exempted deposits, provided they should submit a declaration stating that lend money is out of own funds, and same shall be disclosed in the financial statements board reports. Next one, promoter loans. Simply promoter margin money. So it should be unsecured loan, and because of stipulation imposed by the lending institution, until the loan balance becomes zero, that is an exempted deposit only. Next one, business advances. In case of cancellation of contract, refund within 15 days, adjustments not allowed. Trade advances, adjustment happens within 365 days. Immovable property advance, security deposit, long-term project advance, AMC, EWC, this advance money, it should be up to standard business practice or 5 years, whichever is lower. If standard business practice is 3 or 5, whichever is lower means 3. If standard business practice is 6 or 5, whichever is lower means 3. So 6 or 5, whichever is lower means 5. So accepting advance for a tenure up to standard business practice or 5 years, whichever is lower, it is exempted deposit. Sectorial regulators advance, exempted deposit. Subscription for publication in business magazines, exempted deposit. So exempted deposits, you should be very careful. Next one, prohibition on accepting or renewing deposits under this chapter, chapter 5 deposits, does not apply to banking companies, NBFC, housing finance companies. And if companies commit any default in repayment of the deposits or payment of interest on the deposits, then 5 years ban. First they need to rectify, after that 5 years ban period only. Tenure of deposits, demand deposits not allowed. Less than 6 months deposits not allowed, more than 36 months deposits also not allowed. But less than 6 months we had an exception, that is 10% ceiling. Deposits up to 10% of paid up share capital plus free reserves plus securities premium allowed for a tenure minimum of 3 months. Deposit limits, actually the limit is 35% of paid up share capital plus free reserves plus securities premium. And this limit covers not only a new fresh deposits but also existing deposits. Existing plus proposed or new, both put together, maximum 35% of paid up share capital plus free reserves plus securities premium. IFSC companies, private companies, the limit is 100%. But coming to private company, if it is a startup private company, limit is exempted for 10 years from incorporation. For 10 years from incorporation, limits are not applicable. Other private companies, which is neither subsidiary nor associate to other company, borrowings less than twice of the paid up share capital or 50 crores, whichever is lower, no default in repayment of the borrowings. If these three conditions are satisfied, then also limit 100% is not applicable. First, 35% for all. For private companies, IFSC companies, 100%. And these two companies, no limits at all. And next one, eligible company. Eligible company. What is an eligible company? It is a public company with net worth 100 crores or more, or turnover 500 crores or more. For that also 35% is the limit, but classification is there. 10%, maximum 10% from members, 25% from non-members. Interchange not possible, and this classification is not applicable to government company. Remember these points. Acceptance of deposits from the members, OR is enough. Under section 73, OR is enough. From the public, only eligible public company can accept deposit from public. For that, special resolution is required. Of course, if borrowing powers not exceeded, outstanding loans plus proposed deposits put together, if they are within the limits under section 180 subsection 1 clause C, then OR is enough, no need of special resolution. Joint depositors, maximum 3 persons can hold a deposit receipt. Premature repayment allowed, but tenure should be more than 6 months, because deposits can't be repaid within 6 months of acceptance. After 6 months, in case of premature repayment, interest cut will be 1%. Suppose company agreed to pay 8% and you are claiming your amount before expiry, then 1% rate cut, 7% is applicable rate. Failure to repay deposits resulting in 18% penal interest per annum for overdue period. And deposit repayment reserve, it should be 20% of the deposit maturing in the next financial year. So these are the exceptional topics I identified, but let's go with notes also one time. Let's go with notes. Any missing points I'll see and I'll discuss with you just immediately. See ma, circular ma, important point, circular. Conditions for accepting deposits, circular. Circular should contain these particulars: financial position, credit rating, number of depositors, amount due. And this circular validity period is very important. Maximum validity 6 months from the financial year closure date, or AGM actual date, or AGM due date, whichever is earlier. And copy of circular should be filed with ROC within 30 days before issue date. Deposit repayment reserve shall be created by 30th April, which is 20% of deposits maturing next financial year. Certification as to no default by the company auditor, and even if this default is there, rectified and 5 years has been elapsed, that declaration, that clarification or certification from company auditor is required. Provision for security: company may accept secured deposits or unsecured deposits. If it is unsecured deposits, disclose word unsecured. In case of secured deposits, charge should be created on tangible assets, covering not only market value, should cover not only deposit amount but also interest amount. Next one, DRR shall be utilized only for repayment of the deposits. But these conditions are not applicable to private companies accepting deposits up to 100% of the paid up share capital plus free reserves plus securities premium, or startup up to 5 years from incorporation, or a private company fulfilling the 3 conditions, neither subsidiary nor associate, borrowings up to twice, less than, borrowings less than twice of the paid up share capital or 50 crores, whichever is less, and no default in repayment of the subsisting borrowings. And all these companies must file DPT3 with ROC. So with respect to limits, IFSC companies, private companies can go up to 100%. Just now I told you. Startups up to 10 years from incorporation date, no limit applicable. And private companies with these 3 conditions compliance can also deposits without any limits. Deposit receipt shall be issued within 21 days from receipt of money. Remember, within 21 days from receipt of money, deposit receipt shall be issued. So all these points I have covered. Depositor trustee disqualification, similar to debenture trustee. So KDP employee of cash companies. Next, relative of the KDP also disqualified. Depositor disqualified. Indebted, debtor is also disqualified. Pecuniary relationship with company disqualified. Surety also disqualified. For removal, consent of all directors present at the meeting required. In case company is having independent director, at least one independent director should attend the meeting and should give consent for removal of the depositor trustee. Exceptional point. Entries in the deposit register should be done within 7 days from the event. Preserved till 8 years from the latest entry. That means after repayment you will write the entry, right? From that date onwards, within 8 years, up to 8 years, this register shall be preserved. Premature closure, 1% rate cut is there. But exceptional cases like, national emergency, war time, during the time period, or to comply with the provisions, to comply with this 35% limit, company wants to repay some deposits. So in both the cases, rate cut is not applicable. Punishments, give one time reading. Company 1 crore or twice the amount of deposits accepted, whichever is lower, maximum 10 crores. Officer in default, imprisonment up to 7 years and minimum 25 lakhs, maximum 2 crores punishment. Intention to deceive, 447 punishment. Repayment of old deposits, right now that is not relevant because already over. Deposits accepted under old act must be repaid within 3 months of commencement of the provision, or within 3 years of the commencement within 3 years of the commencement or original due date, whichever is earlier. But ROC shall be intimated ROC shall be given information about the old deposits within 3 months of commencement of this section. So that's it hardly 10 minutes for deposits. Next, charges, small chapter, important. Here exceptional topics, conversion of floating charge into fixed charge. Floating to fixed, we call it as crystallization. It happens in the following cases: when the terms of floating charge are violated, company stops operations, company enters into liquidation, or creditor enforces the security covered by the floating charge. In all these 4 cases, floating charge will be converted into fixed charge. And what is the time limit for registration of charges? Up to 30 days normal fees, 30 to 60 days additional fees, 60 to 120 days ad valorem fees. Of course, ROC approval is also required. But important point is triggering point. Sir, what is the triggering point for registration of charge? Is it date of creation of charge, or is it loan availment data? Suppose I applied for a loan for which I registered a mortgage deed in favor of the banker. Today, I registered mortgage deed. And I started using funds after 3 months. After 3 months, I started using funds. Now, what is the triggering point for registration of charge? From the date of utilization of funds or from the date of creation of mortgage deed, it's date of creation of mortgage deed, simply date of creation of the charge. Remember, date of creation of charge is the triggering point. So whenever official receiver has been appointed by the charge holder based on the instrument or based on the court order, so they must give intimation, they must give notice to the company and ROC within 30 days of the order or within 30 days of the appointment. So this notice shall be given not only at the time of appointment but also at the time of termination also. Registration charge will act as a constructive notice. Doctrine of constructive notice. Powers of central government in case of any misstatements, mistakes in the documents filed with ROC or the registers, or there is a delay in filing documents with ROC, satisfaction of charge, there is a delay, then apply to central government. If central government is satisfied that this delay or omission or misstatements or accidental, inadvertence, or there is a sufficient cause, then central government observe there is no negative impact on the creditors. If central government observes there is no negative impact on the creditors, then it will give consent to modify the earlier filed documents. Rectification, simply rectification. So if you go with the handwritten notes, floating charge, fixed charge, differences just give one time reading. Nature of assets, if you see, fixed in nature, not fixed in nature, permanent assets, whereas here changing in nature, like stock and book debts. Hypothecation, mortgage. Asset can't be sold without charge holder consent. Here can be sold. Of course, upon crystallization, you can't sell them. So yes, charge holder can also register the charge. Yes. And verification of charge instrument, if property is located in India, no problem. Located outside India, verified under common seal or director or a company secretary or person interested person. In India, that interested person is not there, director, CS, charge holder or authorized officer. In case of non-registration of charge, the charge becomes void against liquidator. That means debt is still valid only, but charge becomes void. That means you will lose secured creditor position. You will be treated as unsecured creditor only. So charge holder can also register the charge. For that, if he is filing an application, ROC will give a notice to the company and will wait. If there is no response from the company within 14 days, then ROC registers the charge and ROC authorizes charge holder to recover the fees from company. So modification of charge, section 77 is applicable. You need to register modifications also. Register of charges 81. ROC maintain register of charges for every company. Open to inspection on payment of fees. MCA portal will act as a register. With respect to company, every company must maintain a register at its registered office. All charges, copies of charge instruments, entries by the director, CS, authorized person. So all charges relating to the company. Also copy of charge instrument should be preserved at registered office. Inspection during business hours by the members, creditors, no fees chargeable, no chargeable fees. For others, fees is chargeable, prescribed fees. Preservation, register, no compromise till liquidation. Whereas charge instruments, 8 years from satisfaction. And satisfaction of charge, normal time period 30 days, give notice to ROC. Extended time period 300 days. That means extra how many days? 270 days. ROC will give notice to the charge holder. If there is no response from the charge holder for a period of 14 days, then ROC assumes there is no objection of charge holder. Accordingly, register the satisfaction of charge. But if charge holder is giving consent, if charge holder himself is giving NOC to the ROC, if charge holder is signing the satisfaction of charge instrument, then intimation to charge holder is not required. Of course, ROC is having suo motu powers to make entries regarding satisfaction of the charge. ROC is having independent powers not affected by the company's failure to notify, and intimation shall be given to the affected parties within 30 days of making the entry. Issue certificate. 84 I covered. 86 punishment for contravention. 87 also I covered. 6 minutes, not even 6 minutes, 5 to 6 minutes, charges chapter also over. Next, very big chapter, MGT. Entries in the registers must be made within 7 days of board approval. transfer approval, transmission approval, allotment approvals, whatever the event, within 7 days of board approval, make necessary entries in registers. Of course, if it is a pledge by the promoters of a listed company, those particulars shall be updated in the register within 15 days. Ma, what is the general rule? 7 days, ma. To this general rule, any exception is there? Yes. What is that exception? Promoters of a listed company, if they create any pledge on their holdings, those particulars shall be updated within 15 days. 15 days, not 7 days. Declaration of beneficial owner, member to company, registered member to company within 30 days of getting shares in his name without beneficial interest, form number MGT4. Beneficial owner to the company within 30 days of acquiring beneficial interest and form MGT5. Company to ROC, filing should be done in MGT6 within 30 days of receipt of information from members as well as beneficial owners. SBO limits at 10%, ma. So beneficial owner, significant beneficial owner, the difference significant, 10%. Not directly, but directly and indirectly. Direct plus indirect together 10% or more, I'll be treated as SBO. Closure of registers. Closure of registers. If a company wants to close registers, 7 days prior intimation should be given. In case of SEBI may also prescribe a shorter period. SEBI can prescribe shorter period, but as per Companies Act, 7 days before closure notice should be given, and registers can be closed up to 30 days at a time, up to 45 days throughout the year. So one time 30 days you can close, but throughout the year total closure period shall not exceed 45 days. Next one, annual returns. Annual return must be filed with ROC within 60 days from the AGM. If AGM is not conducted, then within 60 days from the due date of AGM, also mention the reasons for not holding the AGM. Certification of annual return, MGT8, applicable not to all companies but to the 3 companies. Listed company, next others with paid up share capital 10 crores or more, others with a turnover 50 crores or more. Certification of annual return is required. Meetings held at shorter notice. So what is the notice period, ma? What is the notice period? 21 clear days. 21 clear days. Clear indicates date of service of notice and date of meeting shall be excluded. And if you are sending notice via post, 48 hours shall be added for putting the same into the transmission. Okay. If and forgot Section 8 company. For Section 8 company, it's not 21 clear days, 14 clear days. For shorter notice means less than 21 clear days or 14 clear days. Notice will be valid if requisite approval has been obtained. What is that approval? In case of AGM, at least 95% of the members entitled to vote. Here we are giving importance to the members. In case of AGM, company with share capital, majority of the members, more than half of the members, holding 95% of the paid up share capital carrying voting rights. Company without share capital, majority 95% members, no limit on members, but limit is on 95% of the total voting power. If member has voting rights only on certain resolutions, counted for those resolutions, not counted for remaining resolutions. Lack of quorum, remember ma, if a meeting is called by board of directors, lack of quorum, within 30 minutes, meeting stands adjourned to the same day, same time, same place in the next week. If meeting is because of requisition is under section 100, no quorum, meeting is not adjourned, meeting is cancelled. If quorum still not present at adjourned meeting, members present form quorum. See, this is exceptional point, ma. Meeting because of requisition is no need to check for quorum. If there is no quorum, quorum should be checked. If there is no quorum, meeting will not be adjourned, meeting will be cancelled. Of course, AOA may prescribe higher quorum. You all know the limits, right? 2 MPP in case of private company, 5, 15, 30. Depends on limits, ma. Up to 1000 members, 5. 1001 to 5015. 5000 above, that means 5001 and above, 30 members personally present shall constitute the quorum. Quorum includes representative of the body corporate, president, governor, excludes proxy. Here exceptional point is, suppose a person representing 2 body corporates, B limited, C limited, attending AGM, he will be counted as not 1, he will be counted as 2, representing B limited as well as C limited, right? Count will be 2. And representatives of body corporate, president, governor is deemed to be the member, not proxy. And while counting quorum, proxies are excluded. Quorum should be present throughout the meeting, right? Exceptional point. Quorum should be present throughout the meeting. Suppose for few business items quorum is there, for remaining items quorum is not there. For remaining items meeting is adjourned. Explanatory statement. Whenever company is calling for a meeting for in which some special business items to be transacted, then explanatory statement is mandatory. Of course, remember, explanatory statement is not mandatory if that meeting is because of requisitionist. Interest of KDP relatives, KMP, director, promoter, relatives to be disclosed. If financial interest, in case of financial interest, 2% or more of paid up share capital shall be disclosed. Less than 2%, no need to be disclosed. No need to disclose. If provisions are violated, defaulting promoter, director, manager, KMP liable for a penalty of 50,000 or 5 times the benefit received, whichever is higher. 50,000 or 5 times the benefit received, whichever is higher. That is a punishment, section 102. Next one, chairman casting vote. Chairman casting vote is allowed subject to two conditions: AOA authorization. Second one, equality of votes. That means votes in favor is equal to votes against. If these two conditions are satisfied, chairman will get second vote as a casting vote. Next, proxy. Single proxy can represent maximum 50 members or represent 10% of the share capital carrying voting rights. So proxy cannot vote on show of hands, but proxy can demand for poll. Members holding more than 10% of the total share capital carrying voting rights can appoint one proxy, but the appointed person cannot act as proxy for other members. Appointed proxy should represent only me, but not other members. In case if I am holding 10% of the more than 10% of the total capital, because here you can see proxy can represent maximum how much voting share capital? 10%. If I am holding 15%, I can have one proxy. The appointed proxy will act as proxy only to me, but not for other members. That means other members cannot appoint the same person as a proxy. Latest proxy submitted within time is valid. Say for example, M appointed proxy P, proxy Q. Both proxy forms received by the company. For example, proxy P received by the company on 12th September, proxy Q 15th September. So latest deposited proxy form, that too you need to check the time limit, 48 hours before meeting. If proxy form in favor of Q is received by the company 48 hours before meeting, then Q proxy will be valid. Latest deposited proxy form will be valid. That too timely submission is also required. Voting right of a member in Nidhi company, I already told you, it is limited to 5% only. For deposit of proxy forms, 48 hours before meeting commencement time. And inspection notice shall be given 3 days before meeting. Inspection start time 24 hours before meeting, end time conclusion of the meeting. When the meeting is getting concluded, so inspection will be concluded. Companies required to provide e-voting facility. These two companies, listed companies and 1000 or more members. Company having 1000 or more members, for them e-voting is mandatory. So in a company 1200 members are there, e-voting is mandatory, but e-voting is not applicable to two companies, Nidhi companies and institutional investors, enterprises or institutional investors, for them also e-voting is not applicable. Scrutinizer may seek assistance from a non-employee expert familiar with electronic voting system. So non-employee, not employee, he must be non-employee, outsiders, independent persons, technically, professionally, as well as independent persons. Who can demand a poll? Both members proxy can demand poll, but they must have at least 1/10 of the voting power or paid up value of 5 lakh rupees. Sir, what is the time limit for conduct of poll? Poll should be conducted immediately for two matters, No waiting, immediately for two matters. One is appointment of the chairman and second one is adjournment of the meeting. For these two matters, poll should be conducted immediately. Other matters, poll can be conducted within 48 hours of demand for poll, 48 hours. And poll can be demanded on or before declaration of results. Declaration of results under show of hands. For companies without share capital, poll can be demanded by the persons, members or proxy if allowed. At least they must have how much total voting power? 1/10 of the voting power. A company must transact specific business items. Some 10 items are there. So compulsory postal ballot. And for other items, optional. But for 6 items, ordinary business items, adoption of financial statements, declaration of dividends, director's appointment in the place of retiring one, auditor appointment and fixation of remuneration, and the items where director or auditor is having right to be heard. For those two items also, postal ballot is strictly prohibited. Postal ballot is strictly prohibited. Remember this point. Under postal ballot, 30 days, voting period is 30 days. So you need to deposit postal ballot form with the company in 30 days. If a resolution is passed at adjourned meeting, effective date of resolution is not original meeting date, but adjourned meeting date. Adjourned meeting date. Exclusion from the minutes. Chairman is having absolute discretionary powers to include or exclude above three matters: defamatory, irrelevant, detrimental to the company interest. Signing of minutes. Board meeting minutes shall be signed by chairman of the present board meeting or next board meeting. Here, no time limit for signing. No time limit for signing. Whereas, general meeting minutes, so postal ballot minutes, chairman of the general meeting, or in the absence of chairman of the general meeting, director authorized by board shall sign the minutes, and the two signing of minutes time limit is 30 days. First, minutes should be kept ready within 30 days. That is common for all the minutes. But signing of minutes, no time limit for the board minutes. Whereas for general meeting minutes, postal ballot minutes, it should be signed within 30 days only. If chairman is there, chairman. Chairman is not there, authorized director. Written and signed requisition by the members. Section 100 and section 111, circulation of members resolution. So they must have 1/10 of the paid up share capital carrying voting rights as on date of receipt of requisition by the company. When you are filing it, when you are preparing it is not a matter. When company receiving it, you have to check the date. On the date, 1/10 of the paid up share capital in case of company with share capital. In case company without share capital, 1/10 of the total voting power. Signatures may be on multiple copies of the requisition. Time of deposit. Sir, when to deposit this requisition? Circulation of members resolution. If you want resolution to be passed at the meeting, you have to deposit it with the company at least 6 weeks before meeting. No sir, just a statement sir, at least 2 weeks before meeting. Next, time limits do not apply if AGM is scheduled within 6 weeks of deposit. Today, I'm asking company, include this matter for which resolution should also be passed. So far, notice not issued. So far, company not issued any notice. But after deposit of this form, company immediately issued a notice calling for that meeting. Now, for this 6 weeks time limit, applicable or not applicable? Not applicable. And to avoid unfair publicities, some people play cheap tricks. To avoid them, some reasonably sufficient to meet circulation expenses must be either deposited actual performance or unconditionally tendered attempted performance. Next, report on AGM applicable only to the listed companies. Applicable only to the listed companies, shall be signed by the chairman. In the absence of chairman, 2 directors, one must be the managing director, and if CS is appointed, CS also should sign report on AGM. It should be filed with ROC within 30 days of AGM. The next one, AGM deadlines. AGM TDP. Time, any time during business hours. Commencement time should be between 9 and 6. Due date of AGM. Tell me, first AGM due date within 9 months from the closure of first financial year. Again, financial year. Definition, financial year. Date of first financial year. Date of incorporation on or after 1st January. Then first financial year closure date will be 31st March of following financial year. Other cases 31st March of relevant financial year. So to this add 9 months, that will be the due date of first AGM, and subsequent AGMs within 6 months from the closure of financial year. Time gap between 2 AGMs shall not exceed 15 months, whichever is earlier. Exceptional point, ROC may grant extension up to 3 months. This extension is possible only for subsequent AGMs but not for first AGM. For first AGM, extension is not there. Place at registered office or any place in city, town, village where registered office of the company is situated. Unlisted company, with the consent of all members, AGM can be conducted at any place in India. Day of the meeting, it can be on any day except national holiday. Exceptional point, suppose you fixed 29 September 2026 as AGM date. After issuing notices, central government suddenly declared 29 September as a national holiday. Can I conduct AGM on that date? For that year, you can conduct because notice already issued, arrangements already started. But next year onwards, you cannot conduct AGM on 29 September. So with these selected exceptional topics over, let's go through the material, handwritten notes, any significant points. I'll show you. So section numbers remembering chart is also there. So register of members must be kept ready in how many days? 7 days. Formats MGT1 for members, MGT2 for other securities. Index, very exceptional point. Index is not required if number is less than 50. That means up to 49 index is not required. 50 or more index is compulsory. Location ma at registered office. Register of members at registered office. But with special resolution. With special resolution, you can place them at any place in the city, town, village where registered office is situated, or any other place in India in which 1/10 of the total members, more than 1/10 of the total members reside. More than 1/10 of the total members reside. Next one. These 15 days of such events also I discussed with you. Foreign register, company can open foreign register subject to AOA authorization and intimation to ROC. For that, file a notice with ROC within 30 days in MGT3 about the location and any changes. This section also I covered registered holder, beneficial owner, ROC. Company filings I covered. SBO compliance should be done within 90 days of commencement of the rules. For new SBOs, within 30 days of acquiring or within 30 days of altering SBO interest, file BEN1 with a company, and company will file BEN2 with a ROC. Actually 30, but at the time of commencement of the rules, transition period 90 days. And for SBO, 10% of the shares, 10% of the voting rights, 10% of the dividends. Criteria: alone plus others, not alone. If alone, why beneficial ownership concept comes? Alone plus others. That means directly and indirectly. These are the steps you can see. If company is having a doubt on any person, might be SBO, give BEN4. Ask that person to comply within 30 days. If not complied or fails to provide necessary satisfactory information, then file an application within 15 days with NCLT. NCLT orders to impose restrictions on transfer, suspend their rights. NCLT may pass such order within 60 days of application. And any person on whom restrictions have been imposed may request NCLT to remove the restrictions, but that application should be filed within 1 year of NCLT order. If there is no such response, NCLT may order to transfer such shares to IEPF. And this is also important point, exceptional point, not important, exceptional. SBO rules are not applicable to these entities. Government entities, local authorities, government controlled bodies, mutual funds, REIT, investment trust, other SEBI regulated entities, investment vehicles, IEPF authority. Next, total section. Government company is exempted, but that government company should be regular in section 92 and section 137. That means filing of annual returns, filing of financial statements. This I covered. Annual returns, signing by the director. In case company is having CS, director and CS. If no CS, director and practicing CS. For OPC, director signature enough. CS or practicing CS signature is not required. Certification also I covered. So time limits I covered. MGT7 for all companies. MGT7A is for OPC and small companies. Registers returns. Place, of course, registered office. With special resolution, you can place them at any place in India where more than 1/10 of the members reside. Next, preservation. Register of members permanent. Register of debenture holders 8 years post redemption. Foreign registers same rule. Annual returns 8 years. Up to 8 years of filing annual returns you need to preserve them. Inspection allowed members debenture holders no fees. Outsiders prescribed fees not exceeding 50 rupees. Inspection maximum minimum 2 hours per day inspection should be allowed. If you want to take extracts or copies, you have to pay fees and this I already told you. Section 17. So whenever there is a request from the member, and there should be also deposit of fees. After deposit of fees and return request, then company should give these documents within 7 days of the request. Of course, charge shall not exceed 10 per page. Fees expenses shall not exceed 10 per page. Next one. Registers, indices, annual returns maintained under this Companies Act will act as an evidence. Notice of the meeting, 21 clear days I told you. Notice shall be given to all the members. In case member got deceased, legal representative. If member become insolvent, official SNE, all the auditors and directors of the company. Board resolution is compulsory. Without board resolution, if notice is given, that notice is not valid. Of course, it can be ratified by the directors. Omission, oh my god, omission of notice, if it is intentional, meeting invalid, all the decisions taken at that meeting also invalid. Accidental omission, no impact on meeting proceedings. Shorter notice I covered. Explanatory statement also I covered. Effect of non-disclosure I covered. Quorum, yes, all the points I covered. AOA, whichever is higher, remember this point. Within 30 minutes quorum should be there, or else all other meetings adjourned, EGM because of requisition is cancelled. For adjourned meeting, 3 days notice should be given, at least 3 days. Not possible, give advertisement. One person representing multiple corporates counted as multiple. Quorum must be present throughout the meeting. Members voting remotely attends the meeting, still counted. Members already exercise voting power through remote e-voting. If they attend the meeting, still counted. Related parties counted for quorum. Postal ballot also not applicable. For postal ballot, resolution passed through postal ballot. If meeting is not conducted or conducted also, 103 not applicable. When decision is taken through postal ballot, you tell me what is the purpose of calling meeting. So that's why 103 not applicable. Chairman, casting vote I discussed with you. Proxy, yes, I covered all the points. Yes, in proxy note, notice calling for meeting, disclosure of proxy benefit is mandatory, or else punishment 5,000 rupees. Company is prohibited from issuing invitations to appoint the proxy forms. But if there is a written request, if there is a request from the member, I want persons willing to act as a proxy, then you can circulate that list among the requested members, no problem. So 50, 10%, all is covered. Who can be proxima? Any person, but for Section 8 company, only member can be appointed as a proxy. Important point, who can appoint proxy? No, not all members. Member entitled to attend and vote at the meeting. This is exceptional point. Entitled to attend and vote. Merely attending the meeting, not entitled to vote, cannot appoint proxy. She should satisfy 2 conditions: entitled to attend, entitled to vote. Suppose I already casted vote under remote e-voting. Now I want to attend the meeting. Yes, I can attend the meeting. Can be counted for the purpose of quorum. But proxy appointment for that meeting is not allowed. Because I am not entitled to vote at that meeting. Time limits, inspection time limits also covered. Restriction on voting rights is possible only in 2 cases. Unpaid dues, lien on member shares, but the 2, AOA authorization is required. If AOA is silent, there is no restriction on voting rights. In case of joint shareholders, senior person gets voting rights. Senior person means not age wise but chronological wise. Whose name appears first, that person is entitled to cast vote at the meeting. Reallotment of forfeited shares, new allottee cannot vote until all dues are paid. Normal point only. Poll, demand for poll I discussed with you. 1/10 of the voting power or paid up share capital 5 lakhs. 1/10 of the voting power in case of company with the share capital. Nidhi companies, institutional investors, e-voting is not applicable. Under show of hands, whether resolution is passed or not, what is an evidence? Declaration by the chairman and entry in the minutes will act as an evidence. Postal ballot is not applicable in case company having up to 200 members. Postal ballot is not applicable if a company is having 200 members or less. Postal ballot is not mandatory. Remote e-voting shall be kept open at least 3 days and it will be closed at 5 p.m. before the meeting. Scrutinizer for e-voting, scrutinizer for postal ballot shall be appointed by board, whereas scrutinizer in case of poll, chairman appoints the scrutinizer. Time limits I covered, my immediately 48 hours I covered. Postal ballot, these 10 items mandatory: object clause alteration, AOA alteration, registered office shifting, prospectus objects variation, differential rights, variation of rights, buyback of shares, small shareholder director election, sale of undertaking, loans guarantees mandatory. Other items optional, but to these 6 items, ordinary business items, 4 director auditor having right to be heard, postal ballot prohibited. Circulation of members resolution, 6 weeks or 2 weeks, go through it. Criteria same for requisition also. Types of resolution, special resolution, votes in favor should be at least 3 times of the votes against. Disclosure of special resolution intention and section 101 compliance is required, then only special resolution is valid. Disclosure of special resolution intention is compulsory. Resolution requiring special notice ma. So for these items, 4 items already prescribed ma. Appointment of auditor in the place of other than retiring auditor. Resolution not to reappoint retiring auditor. Removal of the auditor before the end of their term. Appointment of the director. So director. Appointment of, this is a director ma, not auditor. Next. Appointment of the new director in the place of removed director, and AOA may specify additional matters. For this, special notice allowed, but special notice, members holding 1% of the voting power or paid up share capital at least 5 lakhs, any condition satisfied, can give special notice to the company at least 14 days before the meeting, but not older than 3 months, and company duty to serve to the other members at least 7 days before the meeting. If not possible, give advertisement. 116 over 117. Filings with ROC. Board resolution with respect to powers of the board 179.3 shall be filed with ROC, but this is not applicable to banks, NBFC, housing finance companies. Time period 30 days. Form number MGT 14. Filings, attachments, resolution copy or agreement copy, along with that explanatory statement also. See, there is a misconception. For all special business items, special resolution. Ordinary business items, ordinary resolution. False ma. Suppose you take bonus issue, special business. OR is enough. Differential rights, special business. OR is enough. Rectification of name, special business. OR is enough. Minutes, 30 days time limit I told you. Signing is very important ma. Signing is very, very important. Preservation of minutes at registered office or specified place. Time period permanent ma. Permanent. Both the minutes. General meeting, board meeting minutes permanently. Custody, CS or authorized director. Inspection of minutes allowed. I discussed already these points. Documents in electronic form. Responsibility, you have to see. MD, CS, authorized officer. These people are responsible for section 120 compliance. 96 already covered. 9 months, 6 months, 15 months. So time, day, place also covered. Unlisted company, any place in India with the consent of all members. Section 8 company, TDP can be pre-decided in the previous AGM, subject to previous general meeting guidance. Government company, place of AGM, CG will approve the location, but both the cases, the company should not commit default in 92, 137. 92 annual returns, 137 financial statements. If a company fails to conduct AGM under 96, NCLT ordered to call for AGM, and NCLT is also having power to call for or pass an order to call for EGM also. Both the meetings are valid. Even one person attends in personal capacity or proxy capacity, both are valid only. Report on AGM. MGT 15, 30 days of AGM, signed by chairman. If no chairman, 2 directors, 1 should be MD. If CS is there, CS shall sign it. CS shall also sign it. EGM, board of directors on suo motu basis or requisition. In case of requisition, I told you 1/10 of the paid up share capital or 1/10 of the voting power as on date of receipt of requisition. Timelines ma. Timelines, within 21 days call for the meeting, within 45 days conduct the meeting. In case of failure, requisitionists themselves call for EGM, but that meeting should be conducted within 3 months of requisition. In case board of directors are calling general meeting, EGM, it can be conducted at any place, even any place outside the city, town, village where registered office is situated. But if it is a company wholly owned by company incorporated outside India, then any place including outside India also. But if EGM is called by requisitionist, that meeting shall be conducted on any day except national holiday. National holiday not allowed. Time during business hours, and place either registered office or city, town, village where registered office of the company is situated. If requisition is conducting EGM, reimbursement of reasonable expenses. Company will reimburse and company will deduct the same amount from the salaries of the defaulting officers. Oh, that's it. MGT over. Hardly I took 30 minutes. Of course, exceptional topics discussion I took 15 minutes. Remaining points, handwritten notes, another 15 minutes only I took. Next topic, dividends. Two companies are prohibited from declaration and payment of dividends. One is Section 8 company, other one is Section 73 non-compliance company, deposits non-compliance companies. Sir, can company declare dividends without transferring certain portion of profits to the reserves? Yes, transfer of profits to reserves is at the discretion of the company. Members cannot increase the dividend rate recommended by the board of directors. Members can reduce it. Members can maintain same rate, but members cannot increase the dividend rate. Declaration of dividend in case of inadequate profits or losses. Inadequate profits or losses. 4 conditions. Dividend rate shall not exceed average of 3 preceding financial year dividend rates. Average of 3 preceding financial year dividend rates. Of course, this is not applicable if dividend is not declared in the last 3 years. Amount to be withdrawn shall not exceed 1/10 of the paid up share capital plus free reserves. Post withdrawal, balance in free reserves should not be below 15% of paid up share capital. Once amount is withdrawn, first set of current year losses. In a regular marathon class, I also solved one problem covering these conditions. Go through it. Since this is exceptional topics marathon, my motto to cover maximum exceptional points and important points within a shorter duration, say for example some 3 to 4 hours. So that's why I'm not going much detail. So these 4 conditions to be satisfied, First condition is from rate point of view. Remaining 3 conditions are from amount to point of view. Unpaid dividend, key time limits. Observe carefully. Yeah. Just exceptional topics. Yes. D0, dividend declared date, declaration. From here onwards, by day 5, transfer dividend amounts to separate bank account. From here onwards, day 30, payment should be done. If payment not done, if dividend not claimed, from here, that means here I'll treat it as D0, day 0 or day 30 of declaration, or freshly day 0. From here onwards, within 7 days, transfer amount to unpaid dividend account, UDA, unpaid dividend account. Within 90 days of such transfer, to unpaid dividend account, prepare a statement comprising 3 informations. One is members whose dividends remain unpaid or unclaimed, their last known address, and dividend amounts unpaid or unclaimed, and publish it on the websites. Wait for 7 years if not claimed. 7 consecutive years if dividend remains unpaid. Dividends, shares shall be transferred to IEPF. Any one single year if he claims dividend. So 7 consecutive years is not there. Shares remain with member, whereas dividends which were transferred to unpaid dividend account exceeding 7 years for a period more than 7 years shall be transferred to IEPF. Simple point only, limits, separate bank account 5 days, payment of dividend 30 days, transfer to unpaid dividend account 7 days. In case of delay, interest shall be added. Statement, file statement within 90 days. Publish statement on the website within 90 days containing 3 points. 7 consecutive years dividend remain unclaimed, transfer shares to IEPF. Applicability to nidhis. If dividend payable is 100 or less, the company can announce the dividend in local language in a local newspaper and on the notice board for at least 3 months. Then company is said to be in compliance with section 127. All these sections have been complied. Nidhi companies can pay dividend by creating members account if not claimed within 30 days from the declaration. Nidhi means it's a small bank only. It's like a bank only where members deposit their savings. Members borrow money for in case of need. So directly amount will be credited to his account. Section 127, non-payment of declared dividend within 30 days attracts punishment. Director, punishment. What is the punishment? Fine up to 1,000 rupees. 1,000 rupees per day, imprisonment up to 2 years. Next, company has to pay interest at the rate of 18% per annum for the delay period. But this punishment is not applicable in the below mentioned 5 cases. Non-payment of dividend is due to operation of law. Shareholder gave a direction, unable to comply the direction, and company has informed the shareholder. If you look into the past examination papers, company, if it fails to communicate if company fails to inform the shareholder, exemption is there, punishment is there. Punishment is there. Communication by company to the shareholder is compulsory. There is a dispute regarding ownership of the shares or right to receive the dividends. Dividend has been adjusted against any dues owned by the shareholder to the company. So dispute as to the ownership, adjustment against lawful dues, and external factors. Default is due to external factors like banking failure, postal strikes, lockdowns. So in those cases, no punishment. Hardly I took 5 to 6 minutes only. Let's see master notes. Any point, any not uncovered point, I'll discuss with you. Sources for declaration of dividend, but before that, interim dividend also we will see. Sources for dividends, current year profits or accumulated undistributed profits or both, or money provided by CG or SG. But these profits means profits after depreciation or before depreciation? After depreciation. Free reserves excludes revaluation reserve, excludes fair value adjustments. Free reserves exclude these two amounts, remember. Next one, interim dividend. In case company is not having profit in the quarter, for the quarter which company is paying dividends. So in that case, average, interim dividend shall not exceed average of 3 years dividend rates. Preceding 3 years dividend rates, average it, there is a maximum rate for interim dividend. Next, 5 days, these conditions are not applicable to 100% government owned companies. Directly transfer to government. Okay, 2 companies are prohibited, I told you, section 8 and section 73. Unpaid dividends, yes, covered. IEPF IEPF credits, IEPF debits. So these amounts are debited to IEPF account. Refund, promotion of investor education awareness protection, distribute discharged amounts among the eligible applicants, reimbursement of legal expenses for class action suits, other incidental purposes. And IEPF authority, IEPF is administered by IEPF authority. Who will appoint or who will constitute IEPF authority? CG constitutes IEPF authority. You can see there will be a secretary who is MCS chairperson. Secretary of MCA is the chairperson of IEPF authority. Other members not exceeding 7 and CEO. With respect to books, meetings, everything CG will prescribe. Accounts, returns, audit, everything CG will prescribe subject to C and AG. So C and AG. After consulting with C and AG only, these norms will come into the picture. So fund accounts will be audited by the C and AG. Annual report shall be presented before both the houses of the parliament. Section 126, a minute, small section only. I'm the member, I transfer shares to another person. We submitted these documents for registration of transfer. Registration is pending. Meanwhile, company announced dividends. Now, to whom company should pay dividends? To the registered member. Already I transferred shares. To the new member. Shares registration not yet done. Registration of transfer not yet done. So in that situation, keep these dividends, hold, abeyance, hold. But if there is a direction, express direction from the member, from the original shareholder, pay dividends to that new person, company will pay dividends to that new person. Until then, not only dividends, rights, bonus also kept in abeyance. Punishment covered. Nidhi company point also I covered. At least 3 months. Notice board display shall be there. Hardly 2 more minutes. Next, accounts of companies. Next one, accounts of companies. First, exceptional cases. Financial statements, 5 components. Balance sheet, profit and loss statement, cash flow statement, statement showing changes in equity, notes to accounts. But cash flow statement is not applicable to OPC, small company, dormant company, eligible startup private companies. Dormant company is an inactive company, last 2 years, if there is no significant accounting transaction, non-filing of financial statement, annual returns last 2 years, inactive companies. By filing an application, they will get dormant status. Startup companies, private only, private companies, getting recognized by DPIT. Next one, books of accounts. 4 items comes under books of accounts. Receipts, payments, sales, purchases, assets, liabilities, cost records. 4 items comes under books of accounts. Books or paper is broader than books of accounts. Books and paper, Books and paper is broader than books of accounts. It covers not only financial records but also non-financial records. Physical books must be kept in India, either at register office or any other location in India, subject to members' approval. No, subject to board resolution and filing with ROC AOC 5. That should be done within 7 days of board resolution. Daily backup compulsory, must be located in India. CG may direct a preservation period beyond 8 years. Actually, what is the preservation period? 8 years ma. Last 8 years books of accounts you need to maintain. But if CG orders to maintain more than 8 years, then that company should maintain books for a period more than 8 years. Inspection of books of accounts is done allowed only by the director. Any director, executive or non-executive or not a matter. But subsidiary records can be inspected by only authorized director, not by representative, only authorized director. Within 15 days of written request, company must provide foreign financial information. If company is having foreign branches, director wants foreign financial information, then company must produce that information within 15 days of written request. And person responsible under section 128 are MD, whole-time director in charge of finance, CFO, any other person charged by the board. In case of section 129, persons responsible, financial statements, person responsible, same people, MD, whole-time director in charge of finance, CFO, any person charged by the board. If these persons are not there, then all the directors. Okay, now next one, exemption from consolidated financial statements. This is not CFS, this is not cash flow statement, this is consolidated financial statement. Consolidated financial statement is not applicable to a company if that company having subsidiary, the same company is also having holding company. I'm having subsidiary, I need to prepare consolidated financial statements, but I'm having one holding company and myself should be unlisted company, and I should have obtained no objection from all the members, all other members. I should have proofs also. I should be unlisted company, and if my ultimate holding company prepares and files consolidated financial statements with ROC, then I'll be exempted from consolidated financial statements. In one MCQ I have seen consolidated financial statements covers financial figures of subsidiaries, associate company, joint ventures, partnership firms also. In one MCQ I've seen it. I'll discuss with you in separate videos also, don't worry. Periodical results, section 129A. Central government may require unlisted companies, not listed. Listed companies already they are following it. Unlisted companies, central government may prescribe unlisted companies to prepare periodical results. Period may be prescribed, quarterly, monthly, half-yearly, period will be prescribed, and board must approve the periodical results, and the same should be audited or subject to limited review by the company auditor. File them with ROC within 30 days of the period ends. Voluntary revision of financial statements board report is limited to 3 preceding financial years. Right now, current financial year 26-27, right? So you can revise voluntarily financial statements in case of non-compliance with 129, board report non-compliance of 134, with respect to how many years? 3 years. That means 25-26, 24-25, 23-24. Suppose you revise 25-26 financial statements in this year. Again next year 27-28, can I do revision one more time for 25-26? No, revision is done only once. Once done, that's it. Reopening of books of accounts is limited to 8 preceding financial years. Of course, if government already ordered a company to maintain for longer period, then that longer period books of accounts can be reopened. Reopening is possible only with court or tribunal orders, and grounds are limited to fraud or mismanagement casting the doubts. Next one, companies governed by NFRA, all the listed companies. Unlisted company following any of these following criteria: paid up capital 500 crores or more, turnover 1000 crores or more, outstanding loans, debentures, deposits 500 crores or more as of 31st March of immediately preceding financial year. And special entities include banking company, insurance company, electricity generation companies, companies governed by special acts, body corporate incorporated by an act. Next one, any material material subsidiaries, material subsidiary, material associate companies above. Of course, D point, CGs sometimes may refer few entities to NFRA. Please take care of these entities. Those entities are also governed by NFRA. Material subsidiary associate companies means what? The income or the net worth of these subsidiaries in the group is more than 20% of the consolidated income or net worth of the parent company or body corporate. Sir, once if I come out of this criteria, immediately NFRA will stop governing me? No, no, no. NFRA continues for the next 3 years also. And the NFRA is empowered to debar an auditor from providing not only stat audit but also valuation services. Debar period maximum 10 years ma. Debarment also extends to internal audit, not only stat, internal audit as well as valuation services. Financial statements, next, with that NFRA is over. Financial statements including CFS shall be approved by the board, but coming to the signing, chairman if authorized by the board. In case of no chairman or no authorization, then 2 directors should sign financial statements. One must be MD. And CEO, CFO, CS, if appointed, they should also sign it. If not appointed, no need of those people's signature. And before it is submitted to the auditor for his audit report, for the audit report. In case of OPC financial statements, board report signed by only 1 director. Come on ma, board report of other companies can be signed by chairperson if authorized by the board, or 2 directors, one must be MD, one must be MD. Remember, CEO, CFO, CS not required to sign board reports. Board report is always prepared on standalone financial statements. Next, CSR. While calculating CSR net profits, 2 amounts shall be excluded. One is overseas branches. You earn profit outside India, not in India. That amounts are excluded. Dividend from the complaint Indian companies under section 135. Say I am receiving dividend from 2 companies. One company already complied with CSR. Other company, CSR is not applicable. Now CSR complied company, from that company if I am getting dividend, exclude that dividend amount because it leads to cascading effect. Already they spent CSR on the profits. Again if you are taking that amount, on that also multiplying 2% means double effect. You remember CSR. 2% of the profits. Which profits? Net profit before taxes. Next. So these 2 amounts are excluded. Net worth, how to calculate? Paid up share capital plus reserves less accumulated losses, deferred expenditure, miscellaneous expenditure not written off, revaluation reserves, written back of depreciation, amalgamation reserves. Included or excluded? Excluded. Failure to spend required CSR amount. What is the treatment? Projects are of 2 types ma. Ongoing or other than ongoing. Ongoing project means project can't be finished in the current year. It can be extended to next 3 more years. Maximum 3 more years only. That means including current year, total 4. Excluding current year, next 3. Other than ongoing project means 1 year project only. 1 year project only. So, other than ongoing project, unspent CSR amount shall be transferred to Schedule 7 fund within 6 months from the end of financial year, that is 30th September. Unspent amount for ongoing projects, first you transfer it to unspent CSR account within 30 days. So by 30th April transfer to unspent CSR account, then use it for the next 3 years. If not used within next 3 years, then transfer it to Schedule 7 fund within 30 days after 3rd year ends. That means 30th April. So what is the year you mentioned here? To that add 3 years. That's it. That's it. And you know, ineligible CSR activities, 6 activities are there. Remember, normal course of business, of course it had an exception. COVID time 2022-2023. If you are spending amount on research, if you are a laboratory company spending amount on research for COVID vaccine, allowed. Other than the duration, not allowed. Political contributions, ineligible. Employee centric welfare activities, ineligible. CSR activities outside India, ineligible. But if you are training Indian sports personnel outside India to win medals, to participate in the games, then it is eligible. Marketing linked sponsorship, ineligible. Statutory compliance expenditures, ineligible CSR expenditure. If a company spends more than required amount, then excess amount can be carried forward and claim set off within the next 3 financial years. Set off is possible next 3 financial years. Next, companies with an average CSR obligation of 10 crores or more, see, impact assessment is compulsory. Impact assessment is not applicable for all the projects, but the project on which you have spent 1 crore or more, 1 crore or more, and already the project have completed 1 year back. Then an independent agency will conduct a impact assessment. And for carrying this impact assessment, you know that independent agency can charge fees. How much? 2% of CSR expenditure or 50 lakhs, whichever is higher. Also remember, CSR administrative overheads shall not exceed 5% of CSR expenditures. Administrative overheads. Next, 130 6. Circulation of financial statements at least 21 clear days before AGM. If not possible, take consent from the members. What type of consent? Shorter notice for EGM, if you remember, take that consent. Majority in number, at least 95% of the capital in case of company with share capital. In case of company without share capital, consent of members holding at least 95% of the total voting power. Next, Nidhi company. Members holding shares more than 1000 face value or 1% of the paid up share capital, whichever is less, are entitled to automatically receive financial statements. Big members, automatic, individual notice. Small members, newspaper advertisement with inspection facility is sufficient. XBRL applicability, you all know, to these 4 companies XBRL is mandatory. Once applicable, forever applicable. No change at all, forever applicable. But XBRL filing is not applicable to NBFC, housing finance company, banking company, insurance company. Remember these exceptions. If financial statements are not adopted at AGM, file financial statements with ROC. ROC consider them as provisional. Adopted later at adjourned meeting. File adopted statements within 30 days of adjourned AGM. If no AGM is held, filing should be done within 30 days from the last due date of AGM along with the reasons. If adoption at original AGM is there, file them within 30 days of general meeting date. That's it. Indian company having foreign subsidiaries, having no place of business in India. Foreign subsidiary, no place of business in India. So for them, filings with ROC not required. But Indian holding companies must file those financial statements with ROC, either audited or unaudited, but it should be in English language. If not, obtain certified translated copy. Internal audit threshold limits every year you need to check based on preceding financial year. At any point of time is applicable for loans or borrowings or deposits. For internal audit, the limits are 50 crores paid up share capital, 200 crores turnover, 100 crores borrowings, 25 crores deposits. This 100 crores, this 25 crores, you need to check at any point of time. At any point of time. Whereas 50 crores or 200 crores turnover paid up share capital, we will check as on 31st March. Is turnover criteria based on at any point of time? No, it's a year end. Internal audit report addressed to the shareholders? No, internal audit report is addressed to the board of directors. See, remember, internal auditor can be employee, can be practicing professional. Scope of internal audit will be discussed, will be fixed by internal auditor and management. Management and internal auditor will decide the scope. If audit committee is there, audit committee. If no audit committee, board of directors. DRS in board report, DRS point is there. Director responsibility statement. Total 6 statements We followed accounting standards. What? We followed accounting standards. We applied accounting policies consistently. We maintained proper records to protect the assets and prevent the fraud. We prepared accounts on going concern basis. We ensured internal financial controls are adequate and effective. We had proper systems to check legal compliances and they're working effectively. You know what? 13 minutes I took for exceptional topics of accounts. But we will go through the material also. We'll go with material also. Uncovered important points I will discuss with you. Financial year if you want to follow different financial year, if you want to follow different period as a financial year, because you're having a holding or subsidiary or associate company outside India, if you want to follow different financial year, application should be filed with CG, not NCLT, CG. Startup company, I told you, Department of Commerce and Industry. So if they give recognition to the private company, then it is a startup company. Books of accounts, accrual basis, double entry system, no compromise at all. No exceptions, no compromise. Accrual basis compulsory, double entry system compulsory. Covered. Branch office books of accounts can be maintained at branch office, but board resolution and filing with ROC, AOC 5 mandatory. Within 7 days, AOC 5 should be filed. Inspection I covered. Preservation of books of accounts 8 years. 8 years. Books of accounts in electronic form. Here audit trail must be there. Edit log must be there. Audit trail cannot be disabled. Daily backup should be maintained in India. Backup in India only. They should be remain accessible in India. I have seen 2 times question like this, the The books of accounts remain accessible outside India. Allowed or not allowed? Not allowed. Accessible in India. Schedule 3, financial statements format. Schedule 3, yes, accounting standards applicability. This I covered, important I covered. Non-compliance of ASMA, you have to disclose the reasons for deviation. First, which standard deviated, what are the reasons for deviation, and financial effects of deviation also you need to discuss. You need to disclose. Periodical financial results over. Reopening, authority is with court of competent jurisdiction, tribunal. Application can be filed by these people. But here reopening will be done only when there is a doubt that financial statements were prepared fraudulently or affairs were mismanaged. Voluntary revision, remember 3 years only, 3 preceding financial years, that too limited to section 129, section 134 compliance only. NFRA, everything, NFRA duties, just give one time reading. Last 2 times, May and September 25 attempts, continuously NFRA duties question came. Next, board report signing also I covered. Contents of DRS I covered. CSR, ineligible CSR expenditure, we have seen it. Applicability of CSR, 500 crores or more net worth, turnover 1000 crores or more, net profit 5 crores or more. Important point is you have to check preceding financial year financial parameters. Say for example, first half yearly my turnover is 2000 crores. For the next half year, for the second half year, should I constitute CSR committee? Should I comply with CSR norms? Answer is no. CSR applicability will go with preceding financial year financial statements. CSR committee with at least 3 directors, one should be independent. In case of no independent director, CSR committee at least 2 directors. And foreign company, CSR committee shall have at least 2 persons, 2 members. Very important point, if my CSR obligation does not exceed 50 lakhs, important and exceptional point, remember, if my CSR obligation does not exceed 50 lakhs, that means up to 50 lakhs, CSR committee not required. CSR committee not required. Board of directors will execute CSR committee functions. Minimum amount to be spent on CSR, 2% of preceding 3 years average net profits. That's it. I have covered all the points. Maximum exceptional points I covered all. Impact assessment also I covered. Rights of the members to get copies of audited financial statements, 21 days. Shorter period, definitely, majority members consent with 95% of paid up share capital. Of course, for section 8 company, 14 days notice. And Nidhi companies, again I am telling you, big members, individual notice. Small members, advertisement, inspection at registered office. That's it. Manner of circulation, electronic mode is applicable, mandatory for 2 members holding shares in demat form, members who are not holding shares in demat form but given written consent, and for all other members, physical dispatch only. Filing of financial statements, we have seen it. XBRL applicability also we have seen. Internal audit is also over. So with this, accounts of companies also completed. Let's continue with the next chapter, audit and auditors. First one, following persons are not eligible for appointment as an auditor of the company. Who? Disqualified persons. Who? First, body corporate except LLP. LLP is qualified. Next, employee of the company disqualified. Officer of the company disqualified. Partner of employee, partner of officer disqualified. Employee of employee, employee of officer also disqualified. Next one, self, relative or partner holding any security or interest in group companies, company, associate, subsidiary, or holding, subsidiary of holding, disqualified. But for relative, there is an exemption. That exemption is 1000 rupees face value of securities they can hold. Up to face value, not market value. Up to face value, 1 lakh rupees. Getting my point? But if relative acquires any security or interest exceeding 1 lakh due to bonus issue or rights issue or subsequent purchases, the corrective action shall be taken by the auditor within 60 days of such acquisition or interest, or else disqualified, vacancy in the audit office. Next, self, relative or partner indebted to the company or group companies exceeding 5 lakhs, disqualified. it is immaterial whether company is giving regular creditor, irregular creditor, immaterial. Credit is there, disqualified. That to how much? Exceeding 5 lakhs. Self or relative partner acting as a surety for an amount exceeding 1 lakh rupee, then also disqualified. Person having business relationship with a group companies, disqualified. Person whose relative is a director or in the employment of a company as a director or KMP, also disqualified. See, my relative normal employee of the company, I'm not disqualified, but my relative director of the company, I'll be disqualified. A person who is in full-time employment, disqualified. Appointment for more than 20 company audits, also disqualification only. While counting 20, 4 companies, OPC, small, dormant, private company with paid up share capital less than 100 crores are excluded. And if a person is convicted by a court because of offense involving fraud, fraud important, not all offenses, offense involving fraud, and convicted by court, 10 years disqualification period. If convicted by tribunal, 5 years disqualification period. And as an auditor, he should not provide the following services, prohibited services. I'm not telling them illegal, but as an auditor, or if you are providing these services, you cannot be appointed as an auditor. So to the company, holding company, subsidiary company, you directly or indirectly using your sister concerns, if you're providing these services, account keeping, bookkeeping, internal audit, financial system, information system, design and implementation, actual services, advisory services, banking services, outsourced financial services, management services, other prescribed services. As an auditor, you should not provide, or if you're providing, you cannot be appointed as an auditor. Audit remuneration, auditor remuneration components, 3 components are included. Audit fees, expenses incurred during the audit, facilities provided to the auditor by the company, but excludes other services. Company stat auditor is also a tax auditor. For filing tax audit returns or for handling income tax scrutiny cases, if we charge any remuneration, that remuneration is not part of audit remuneration. And next, retiring auditor cannot be reappointed in the following cases: not qualified or disqualified, or not giving notice, not giving consent for reappointment, or is not giving eligibility certificate, or in AGM a resolution has been proposed or passed to appoint another auditor not to reappoint existing auditor. Next one, removal of auditor. Remember the sequence. First board resolution, file application with CG. Once CG give permission, within 60 days conduct general meeting and pass special resolution. Remember the sequence, interchange not possible. First board resolution, CG approval, next special resolution. For IFSC companies, deemed approval is there. First file an application with CG for removal of the auditor after board resolution. Wait for 60 days. No response from central government. You can assume that central government approved removal of the auditor. Resignation by the auditor, he is having a duty to communicate with ROC, duty to communicate with company, duty to communicate with C&AG in case of government company. And applicable form is ADT 3, time period is 30 days. Within 30 days, communicate with these people. C&AG is not applicable for all companies. C&AG is applicable only for government companies. Auditor rotation. Auditor rotation is applicable to these 3 companies: listed companies, unlisted public company if paid up share capital 10 crores or more, or borrowings 50 crores or more. Private companies if paid up share capital 50 crores or more, borrowings 50 crores or more. So for these companies, auditor rotation mandatory. But principles of audit rotation: incoming firm, outgoing firm, there should be no common partner. Incoming firm, outgoing firm should not work under same network, brand, owner. And if the audit partner joins another firm, outgoing firm, one partner resigned and joining the incoming audit firm, then incoming audit firm is also disqualified for 5 years. Cooling period 5 years. Clear? Branch auditor can be appointed by the members. If not, members can delegate this power to board of directors. Management may appoint branch auditor. Branch auditor, either he can be CA with COP. In case of Indian branches, CA with COP. In case of foreign branches, any accountant qualified to act as an auditor. CPA, for example, in USA. Getting my point? Actually, branch audit shall also be done by company auditor, but if it is not possible, yes, branches can have their own auditors. Getting my point? Appointment authority is with members, but members may delegate that power to management. Main auditor, company auditor, no delegation is not possible. Appointment is by members. Of course, remuneration fixation can be delegated. So just 6 minutes. 6 minutes exceptional topics over. Safe side. Let's go with material also one time. Qualifications, disqualifications, I covered all the points. My qualifications, in case of firm or LLP, majority of the partners should be practicing CS and they should practice in India. Remember this point, ma. Remember this point. Business relationship exception, ma. If they are permitted by ICI and if they are in ordinary course of business, then no disqualification. Qualifications, disqualification, we need to check not only at the time of appointment, but also after appointment. After appointment also we need to check. After appointment, if there is disqualification, vacancy shall be filled by management, board of directors within 30 days. Prohibited services covered. Yes. Audit committee applicable to all listed companies and unlisted public companies if paid up share capital 10 crores or more, turnover 100 crores or more, loans, borrowings, debentures, deposits 50 crores or more. Audit committee is applicable. In that you will find 3 directors. Majority should be independent directors. Majority should be independent directors. Audit committee will make a proposal of selection of auditor. First they select the auditor, they will propose to board of directors. Board of directors further recommend to members at general meeting. If board of directors are not convinced, they may refer back recommendation to audit committee. Audit committee may make fresh recommendation or they may go with the original recommendation. If they are going with original recommendation, board of directors will make a fresh recommendation to general meeting, fresh recommendation to the members at general meeting. Also, they will specify the reasons for disagreement. And next, appointment of auditor, first auditor appointment. These are simple topics only, not exceptional topics. First auditor appointment, non-government company, board of directors within 30 days. If board fails, then within 90 days at EGM members appoint auditor. Government company, C&AG within 60 days. If C&AG fails, board of directors in next 30 days. If board also fails, then members appoint first auditor in the next 60 days at EGM. Subsequent auditors, non-government company appointment happens at AGM by passing an ordinary resolution. Once appointed, continued for 5 years. That means continued till 6th AGM. Continued till 6th AGM. Important point, I'll tell you, just wait. During this 5 years, sir, every year ratification required, sir. Ratification required, not required. I have seen this in one MTP. Ratification is not required during this tenure of 5 years. In case of government company, C&AG appoints subsequent auditor within 180 days from the commencement of financial year. Within 180 days of commencement of financial year. Appointed auditor holds office until the conclusion of next AGM, 1 year only. Non-government companies, 1 term of 5 years. Powers of C&AG. C&AG within 60 days may conduct supplementary audit and comment upon supplementary audit report, or he can also call for a test audit. But to exercise the power of supplementary audit, C&AG can exercise this power only within 60 days. Casual vacancy. If it is due to resignation, board appoints new auditor and appointment shall be ratified by the members at a general meeting within 3 months. Within 3 months. Not due to resignation, then board shall fill up the casual vacancy within 30 days. In case of government company, always C&AG. If C&AG fails, board shall appoint within next 30 days to fill up that casual vacancy. Casual vacancy. Already auditor resignation duties I told, right? So communication. A rotation of auditor also I covered. 1 term of 5 years for individual auditor, 2 terms of 5 years for firm of auditors. Auditor tenure under previous Companies Act is also considered, but transition 3 years period is given. 3 years. That means incompleted period or 3 years, whichever is higher you can serve. In case if your company is covered under rotation of auditors concept. Principles of rotation also I covered. Removal of auditor I covered. So CG, company shall apply to CG using ADT2 within 30 days of passing board resolution. Once you get CG approval, within 60 days, call for a meeting and take special resolution. IFSC company 60 days deemed approval. Removal of auditor by the tribunal. Yes, if auditor is negligent, tribunal may remove the auditor. tribunal shall make an audit order shall not function, that auditor shall not function as an auditor within 15 days of receiving the application. CG then appoint new auditor. Disqualification 5 years, I told you. Convicted by tribunal, 5 years disqualification. Convicted by the court, 10 years disqualification. This point I covered. Powers of auditor, normal access to the books of accounts, right to obtain information, explanation, receive notice, and duty to attend general meeting. So normal points, give one time reading. Even important, normal points only, not tricky. Duties also go through it. In duties reporting of fraud reporting of fraud. If the amount involved is 1 crore or more, report to the central government. And the time limits you have to remember, within 2 days communicate with audit committee or board, wait for 45 days. If they give reply, no problem. If they didn't give reply, upon expiry of 45 days, within 15 days, communicate with CG. If they give if they give reply, within 15 days of the reply, communicate with CG. That means you have to write a letter to MCA secretary. Just wait, yeah. So these 2 points were deleted right now. Manual is not there, online forms only, all forms are electronic filings only. That's why these 2 points are deleted. This is the recent amendment that is there in RTP, that is applicable for May 26. So Ministry of Corporate Affairs. Of course, when you are filing ADT4, it will be filed in MCA portal only, right? So communication with CG only. Fraud amount less than 1 crore, reporting to government is not required. Materiality, reporting to government is not required. So board of directors should disclose the same in board reports. Branch office, I told you, either company auditor or accountant in that country or person qualified to act as an auditor for foreign branches. Appointment is done by members, or in case of delegation, board of directors may appoint branch auditor. Audit remuneration I covered. Cost records and cost audit. Both cost audit and company audit can't be done by single audit firm. Same audit firm can't do 2 functions, cost audit as well as company audit. Remember this point. So cost auditor must be a practicing CMA or firm of cost accountants or LLP of cost accountants. So this restriction, exceptional point. Within 30 days of receiving the cost audit report, company shall submit it to the CG along with explanations for any reservation or qualifications in the report. If CG requires further clarification, company shall provide additional information within the specified time. Fine So this also I covered. Circumstances, retiring auditor cannot be reappointed. Yes. Next, duties of an auditor completed. Just give one time reading. Penalty for non-compliance Penalties, you may have a doubt. Sir, penalties will come in exams. Definitely one question will come on penalties. Definitely one question. If you are not willing to take risk, read them, practice them, revise them. Okay sir, one question only, no problem sir. Then take risk. NFRA and auditor, just give one time reading. So that's it. Audit and auditors also completed. 6 minutes I took for exceptional topics marathon, and for going through the material I took hardly 9 minutes. Next one, companies incorporated outside India. Very small topic. Compulsory 5 marks question. Compulsory. Foreign company. First of all, what is a foreign company? It's a company incorporated outside India, having place of business in India, and there should be some business activity in India. Simply having agents alone will not constitute place of business in India. There should be some business activity, then only it is a foreign company. See, share transfer office, share registration office in India, yes, it is a place of business in India. Employees agents in India, but no business activity, no place of business in India. Board meetings in India, just directors are coming and meeting together. So can I call place of business in India? No. So at least 50% of the paid up share capital, greater than or equal to 50% of the paid up share capital, which includes both equity, preference of a foreign company incorporated outside India if it is held by one or more Indian citizens, one or more companies or body corporates incorporated in India, or combination of above, then it is deemed to be an Indian company. DIC, deemed Indian company. So deemed Indian company should comply with the provisions of Companies Act like all other companies. Next one, ma. Next one. Yes, for foreign company registration, within 30 days of establishment of place of business in India, within 30 days, file FC1 with ROC CRC. Earlier it is New Delhi jurisdiction, but now CRC, center. Okay. In that FC1 attachments, one of the attachment, statement confirming that no director or no authorized representative in India has been convicted or debarred from company formation management in India or abroad. So here you have to remember this declaration should be filed by director and authorized representative, not company secretary. Next one, time limit for submission of forms, ma. You know, here total 4 forms we are having, ma. FC1 is for registration, FC2 is for alteration of the above documents, alteration, FC3 financial statements, FC4 annual returns. You know, first 2 within 30 days, time limit within 30 days of event, within 30 days of the event. Next FC3, the time limit is 6 months. The time limit is 6 months. All documents shall be submitted to ROC within 6 months after the closure of financial year. Additional documents, you know, 3 additional documents are there. Statement of related party transactions, statement of repatriation of profits, statement of transfer of funds including dividends. So what is the time limit? 6 months. But if you request ROC for any special reason, if you have shown, ROC may grant an extension up to 3 months. Up to 3 months. Foreign company shall file annual return form number FC4 for this due date is 60 days of closure of financial year. 60 days of closure of financial year. So 4 forms, 4 time limits. You can remember, ma, 30 days of place of business, 30 days of alteration, 6 months of closure of financial year, FC3 financial statements, 60 days of closure of financial year, FC4 annual return. And you know, if a foreign company want to issue prospectus, yes, it can do so, but it should be filed with ROC first. And prospectus must be approved and signed by the chairperson. 2 directors certification is also required. On the face of it, disclose the above points. Required consents and prescribed documents must be attached to the prospectus. Non-compliance with chapter 22. That means if FC1 is not filed, then what would be the effect? Simply, if you remember disadvantages of unregistered partnership form, same points, ma. You know, company contracts, foreign company entered contracts are valid, but foreign company cannot enforce it. Outsiders can enforce them. Outsiders can enforce them. So there is no impact on validity of the contracts, but the company cannot show outsider, cannot claim set off, cannot counterclaim, or cannot initiate proceedings until it complies with chapter 22. Last point, display of name and liability. Display of company name and liability. Name and country, as well as in case of limited liability, these two shall be displayed on the name board outside the every location where, you know, outside the building where company is having branches, foreign company is having branches, in 2 languages, English to local language, English to local language. But coming to official documents, coming to what? Official documents, English language is enough. English language is enough. So I took 4 minutes to complete foreign company exceptional topics revision. But if you go with the material, if you go through the material, let's see some 4-5 minutes, ma. Foreign company, identification of foreign company is important first. So place of incorporation outside India, place of business in India, business activity in India. That business activity may be through an agent or physical mode or through electronic mode. Remember this explanation, ma. I forgot to include it in exceptional topics. Electronic security offerings, subscriptions, listings in IFSC under SEZ Act 2005 do not fall under electronic mode. Do not fall under electronic mode. Remember this explanation. So deemed Indian company covered. Documents to be delivered. Yes, I covered this point only. Important. Declaration about compliance or no disqualification is by director and authorized representatives only. FC1 with CRC, ROC, CRC. You can see here, ROC, Central Registration Center. Central Registration Center. And remaining forms, you know, FC2, FC3, FC4, I'll file with ROC having jurisdiction over New Delhi. So in case of ceasing business also, communicate with ROC, then your obligations will comes to an end. Accounts I covered. Time limit important ma. Time limit 60 days. Foreign companies, financial year, if they want to follow different financial year, so make an application with CG. If CG gives approval, that's it. Power delegated to RD. That's secondary. But if CG gives approval, you can follow different period as a financial year. Yes, latest consolidated financial statements of parent foreign company as submitted at its home country should also be filed with ROC. Additional documents, I covered these 3 points. Time limit for submission 6 months. Extended time period 3 more months, but ROC is having power to extend. ROC is having power. So that extension is only for FC3 ma. FC4, FC1, FC2, there is no time limits. I mean, there is no extension. No extension. Display of name I covered. Only if liability is limited, again display it. If liability is unlimited, no need of this point. Service on foreign company, if I serve documents to the place of business registered with ROC, or if I give document to the authorized representative appointed by the company, foreign company, to carry Indian operations, so if I give document to that person, I assume document is given to the foreign company. Authorized person, address submitted to ROC. Annual returns FC4 ma, 60 days is the time limit, 60 days from the end of financial year. So books of accounts, charges, everything is common only. Issue of prospectus, expert statement, this is similar to section 26 only ma. If you want to include expert statement, conditions to be complete, just go through it. And prospectus should be dated and signed. So if you remember section 26 matters, you can have it. But extra points, instrument defining a company constitution, laws under which company was incorporated, Indian address where these documents can be inspected, date and country of company's incorporation, company has a place of business in India. Of course, 1 to 3 points. These 3 points are not applicable to companies which are older than 2 years. If age is more than 2 years, first to 3 points are not applicable because it is already in existence. For new companies only, you need to show proofs whether real or not. All prospectus related provisions. IDRs similar to GDR. GDR, company will enter into an agreement with overseas depository. Here foreign company will enter into an agreement with domestic depository to issue depository receipts in India. IDRs. Compromise arrangement amalgamations. So subject to CG permission ma. Foreign company can acquire Indian company or Indian company can acquire foreign company subject to CG rules and regulations. Violation by foreign company, punishment is in lakhs only. 1 lakh plus to 3 lakhs. 1 lakh to 3 lakhs plus 50,000 per day. Officer in default 25,000 to 5 lakhs. This I covered. Improper use of description as a foreign company, a little bit important ma. So if without authority, without permissions, and you being not a foreign company but still using the description as a foreign company, appropriate action will be taken and investigation will be initiated. CG powers granting exemptions to the foreign companies. So I took 4 minutes to go through 5 minutes to go through foreign company in the master notes. So with this, Companies Act over. Next, LLP, almost over ma. Almost over. Another half an hour. LLP, body corporate definition. Body corporate means company incorporated under Companies Act. Simply, company as per section 2 clause 20. Body corporate means company as per section 2 clause 20. It includes LLP registered in India, LLP registered outside India, company incorporated outside India. But body corporate excludes. Remember, 2 people are excluded. Corporation sole, cooperative societies. Corporation sole, cooperative societies. That means these people can become partners of LLP. No. They cannot become partners of LLP. Financial year, I discussed already in Companies Act for company. But coming to LLP, financial year, 1st April to 31st March, no doubt. But if LLP is incorporated after September 30, say for example 1st October 2026, then financial year closure date will be 31st March 2027. No, 2028. Small LLP, LLP fulfilling this criteria, contribution up to 25 lakhs, turnover up to 40 lakhs, then it is a small LLP. Cooperative society, corporation sole cannot become a partner, I told you. Unsound mind, undischarged insolvent, adjudicated as an insolvent, even minor is also disqualified. DP is responsible for compliance of LLP Act 2008, correct? That means non-compliance of LLP Act provisions, LLP gets punishment, DP also gets punishment. At least one designated partner should be Indian resident. For residential status, we need to check period of stay in the current financial year, during the financial year, at least 120 days. At least 120 days. Rectification of name, this is common for company also. Owner of registered trademark should file an application within 3 years from the incorporation of LLP or change of name by LLP. LLP has to rectify the name within 3 months of CG order. Filing should be done to ROC within 15 days. LLP change the agreement within 30 days of certificate. Same to same. For company, we followed the same. Court or tribunal may reduce or waive penalty for a partner or an employee of an LLP. This is whistleblower concept. If you are cooperative with the investigation proceedings, your punishment may be waived off or may be reduced. So you have to provide useful information, and their information leads to conviction of the LLP, its partners, employees under this act or any other act. Of course, cooperative, the people who are cooperative with the investigation department, they should not be harassed, they should not be demoted, they should not be punished by the company staff, LLP staff. LLP can maintain books of accounts in double entry system, compulsory. But coming to the cash basis or accrual basis, it's up to LLP. They can follow either cash basis or accrual basis, no problem. Company straight away accrual basis. LLP shall prepare a statement of accounts and solvency within 6 months from the end of financial year, and LLP has to file the same with ROC within next 30 days. Preparation of statement of account and solvency, time limit is 6 months. Communication with ROC, next 30 days. LLP shall file an annual return with registrar within 60 days of closed of financial year. Authority for compounding of offences is with RD. And what type of offences can be compounded? Only the offences where fine is the punishment. If imprisonment is there, such offences can never be compromised. Such offences can never be compounded. So compounding of offence is allowed only for the offence where imprisonment is not a punishment. Next, authority is with RD. Authority is lying with RD, regional director. And once you claim compounding benefit, next 3 years for same offence, for similar offence, one more compounding not allowed. Next one, sir, partnership rights can be transferred, but the transferee of partners' rights will get only financial rights, simply economic benefits. He get economic benefits. He won't get management benefits. He won't get management benefits. That means, can he participate in management of LLP activities? No. Can he access LLP transaction information by virtue of transfer alone? No. Management benefits cannot be transferred. Economic benefits like share in profits, these benefits can be transferred. If majority in number, creditors or partners representing 3/4 in value agree to a compromise, then tribunal approves the compromise. Also after issuing order, tribunal will scrutinize, simply tribunal will monitor the compromise or arrangement process. If it is fit, okay, or else tribunal will cancel the order, will cancel the compromise, and tribunal orders for liquidation. Winding up of LLP, voluntary as decided by the partners. Partners reduced below 2, minimum number of partners, minimum 2 should be there, and 2 designated partners. 2 plus 2 4 no, 2 plus 2 equal to 2. 2 normal partners plus 2 designated partners, maximum 2 partners only. That means the 2 partners who are there in the LLP, automatically they become designated partners. Designated partners should be individuals or body corporates? Should be individuals. Partners reduced below 2 months, partners reduced below 2 for a period more than 6 months. Then also, the continuing partner, his liability will be unlimited for the debts contracted by LLP after expiry of 6 months from the date of reduction of partners. Unable to pay debts, acts against sovereignty, integrity of India, tribunal orders on just and equitable grounds. Next one, changes in the partner particulars, changes in the partners, both shall be communicated with ROC within 30 days of the event. First of all, if there is any change in partner's name or partner's address, partner should communicate with LLP within 15 days and LLP should communicate with ROC within 30 days. So notice requirements, prescribed form is signed by DP. DP will authenticate it. Consent, express consent, written consent is required in case of admission of the partner. So late filings, penalty. If LLP does not file exit about the retiring partner, then retiring partner can file with ROC. ROC seeks confirmation. If there is no reply in 15 days, ROC registers the resignation form filed by the former partner. A former partner is still treated as a partner for third partner unless third party knows that he has ceased to be a partner or cessation notice is filed with registrar. So that means there should be some information to the public. If there is information to the public, so former partner is discharged. So that information either you can give it to the public by advertisement, but you should file the same with ROC. Filing a piece of paper with ROC becomes a public document, so everyone is bound by it. Next one, ROC may require any person to answer the questions. This is normal, inquiry, inspection, investigation. Make declarations, provide information in writing within a reasonable period. The fellows may be existing partners, existing DP, or former partners, former DPs, whether present or past. So ROC may ask them, may inquire them. Binding effect of compromise. If 3/4 in value of creditors partners agreed, if tribunal approves, it is valid. It will be binding on all the creditors, all the partners, LLP. If not possible, winding up. In case of winding up, liquidator and contributories are also bound by the compromise arrangement. Tribunal approves only full disclosures is made regarding financial position and regarding investigation status. Powers of the tribunal in case of compromise or arrangement: transfer of undertaking, property or liabilities, continuation of legal proceedings in the name of transferee LLP, dissolution of transferor LLP without winding up, protection for dissenting persons. Winding up, in winding up you will sell all the assets and you will settle the liabilities, right? But in case of merger, all the assets and liabilities of the transferor LLP becomes assets and liabilities of transferee LLP. So no need of winding up, direct dissolution. Protection to the dissenting persons. Incidental or necessary provisions, yes, tribunal can pass such orders. If LLP continues using a deceased partner's name, their legal representative is not liable for LLP acts after death. Partner died and LLP still uses the name of former deceased partner. Whether legal representatives are liable for subsequent acts? No, not liable. So these are the exceptional points, in my opinion. These are the important, expected as well as exceptional points. But if you go through the material, we may find out some other points. First schedule is for rights and duties of the partners and LLP. Remember, Schedule 2, conversion of firm into LLP. Schedule 3, conversion of private company into LLP. Schedule 4, unlisted public company into LLP. One time this concept was tested for 5 marks. One time tested, and 2 times I have seen the same question in MTPs also. Concept of LLP. Simple question actually. Just go through it, read it. Flexibility, corporate structure and flexibility in the management. Definitions, I covered important definitions. Body corporate, okay, financial year, small LLP, I covered. Characteristics, give one time reading. No problem, small question only, easy question only, give one time reading. Advantages of LLP, yes, important. Flexibility, easy to form. Limited liability, easy to dissolve. Partners mark, disqualification. Unsound mind, undischarged insolvent, adjudicated as an insolvent. Yes, I covered these points. Cooperative society, corporation sole, even HUF also cannot become partner of LLP. Minimum number of partners, this is similar to section 3 of Companies Act. Just read it once. Every LLP shall have at least 2 designated partners who must be individuals, at least one resident. One designated partner should be resident in India. So how can we identify designated partner? Go through incorporation document. In case of fall in number of designated partners, you know, 2 designated partners should be there, 1 resigned. Appoint new one within 30 days and communicate the same with ROC within 30 days of appointment. Within 30 days of appointment, just a second, yes ma, yes, in case of number falling below the statutory limit, lawmaker is giving 6 months time period to increase the number of partners, but in case of, you know, designated partner, appointment of designated partner, communicate the same with ROC within 30 days of appointment. Qualification, every designated partner should have DPIN. So here you can see LLP must appoint a new designated partner within 30 days of vacancy. Same point I discussed right now. Liabilities I covered. Procedure for incorporation, if you remember company incorporation procedure, similar points you will find here ma. Similar points, 2 persons, registered office, practicing professional declaration, format, name of the LLP, object clause, situation clause, subscription clause, designated partners, nothing but first directors of the company. You know, in company management we call them as directors. In LLP, management is designated partner. In partnership firm, same people, we call them as active partners. Roles, names are getting changed, roles are same only ma. Penalty for false declaration, important ma. Imprisonment up to 2 years and fine 10,000 to 5 lakhs. Important. Incorporation by registration, yes. Registration of registered office of LLP and changes. One time in one attempt MTP, this point was tested. One MTP in one MTP, this point was tested. LLP can change its registered office by filing a notice with registrar. Importance of registered office, yes, documents will be served to the registered office address only. Effect of registration, similar to effect of registration of company. Name of LLP should be unique, should not be undesirable, should not be identical or too similar to the name of another LLP, company, registered trademark. Name reservation ma, oh my god, thank god, this is important ma. For LLP, name reservation is for a period of 3 months. Once name is reserved, it will be reserved for 3 months. Rectification of name I covered. Relationship of partners, act of one partner, LLP is liable, not other partners. Changes to be communicated with LLP will communicate with ROC. Extent and limitation of the liability. Partner's liability is limited, but you know, partner who is responsible for the fraud, partner is personally liable for wrongful acts. In case of holding out, you know, this fellow is liable. Of course, LLP is liable to this fellow, reimburse that fellow's loss. If LLP receives credit due to false representation, it is still liable for the amount received. Unlimited liability in case of fraud, that's what I am telling you. In case partner acts in a wrong way or defraud the creditors, then the respective partner liability becomes unlimited. Whistleblowing I covered. Partner's contribution, contribution can be in cash, in kind, but monetary value only included in the books of accounts. Monetary value, so should be determined, should be able to be calculated. Okay na? Yes, this is another exceptional point. Watching this marathon lecture, you know, helpful. Even you can cover all the other points also. This is an important exceptional point ma. What is this point? You know, originally partner 1, partner 2 agreed to contribute 10 lakhs each ma. So far they contributed 6 lakhs each, they contributed 6 lakhs. As per LLP deed, they agreed to contribute 10 lakhs each. So on the faith of LLP agreement, creditor gave a loan of 6 lakhs. Even if LLP can't pay the amounts, these fellows, they are liable to contribute to the agreed amounts, to the extent of agreed amounts, right? So even if these fellows bring, you know, 4 lakhs each, my liability is 6 lakhs only, no problem. Like that, you know, he gave a loan. Later, partners modified LLP deed. They made partner's liability as 6 lakhs. Now, outsider is at risk or not risk? Actually at risk, but outsider is protected. Creditor of LLP may enforce original obligation against the partner if extends credit or relies on a partner's obligation in the LLP agreement. So maintenance of books of accounts completed. Annual return covered. False statements, imprisonment up to 2 years, fine 1 lakh to 5 lakhs. False statements with respect to above documents, financial statements, annual returns. Financial statements, annual returns. Power of registrar to obtain information, yes, we have seen this point also. Compounding of offences, I covered. Assignment also covered. Conversion, yes. Complying with schedule 2, 3, 4, depending on the nature of company, partnership firm, okay. Time limits, go through the time limits. Within 15 days of registration, LLP must inform relevant old ROCs or old ROF regarding conversion. Compromise arrangements, yes, I covered it. Power of tribunal to enforce compromise arrangement, except important point ma, already covered. Circumstances in which LLP can be wound up. Yeah, here you see ma, LLP itself decides to wound up by the tribunal. Number of partners fall below 2 for more than 6 months. Acted against sovereignty and integrity. Fails to file statement of accounts and solvency for 5 consecutive years, just and equitable grounds. Yes, this is what, I want to make correction. I just want to make a correction. It's not unable to pay debts. It's purely printing error. Continuous 5 years. Continuous 5 years. Non-filings. Statement of account and solvency. Next, annual returns. 5 years, 5 continuous years not filed. Then LLP order for winding up. So this one change. I'll do the change and I'll re-upload the latest copy in the website. You can download it, okay. In May attempt, I think, May 25 attempt. In the marathon, I told, go through differences also. LLP versus partnership, LLP versus limited liability company. And that attempt, that question came for 5 marks. So just to give one time reading, simple concepts only, don't ignore. LLP versus partnership, LLP versus limited liability company, go through it. One doubt students are having, sir, is this updated version? Updated version only. Recent RTP amendments also covered. So with this LLP also I finished. Next, General Clauses Act. No. Next, FEMA. FEMA, important topic, FEMA. In FEMA, residential status is very important. Here residential status, you need to check for natural persons other than natural persons. For natural persons, residential status comes through period of stay. Period of stay more than 182 days. How many? It's not greater than or equal to, it's greater than 182 days in the preceding financial year, but do not include following people. If any person is leaving India for the purpose of job outside India, business or vocation outside India, intention to stay outside India for uncertain period, even though his period of stay in the current financial year, in the preceding financial year is more than 182 days from the date he left India. That means the moment he leave India, from that point onwards, he is non-resident. He is non-resident. It is immaterial whether in the current financial year he stayed for more than 182 days. Next year also he is non-resident only. One more point, if you want, you can add here, study abroad. Study abroad also, the person will be treated as non-resident only. And a person who is coming to India for employment in India, job in India, intention to stay in India for uncertain period, in this case, preceding financial year, period of stay, even if it is 0 also, current year, from the date he entered into India, he will be treated as resident only, person resident in India only. More than 182 days condition don't apply if a non-resident coming to India for 3 purposes. If a resident is leaving India for those 3 purposes, don't apply more than 182 days condition. Is it clear? So simply non-resident coming to India for tourism purpose. Not for job, not for business, not to stay in India for uncertain period. Just for tourism he is coming. Now he is a non-resident only. Resident leaving India for tourism purpose, then he will be resident only. Resident leaving India for any of these 3 purposes, then he will be treated as non-resident from the date he left India. First May he is in India, he took flight and he went off. Now second next day onwards he is a non-resident only. So next one ma, section 6 ma, section 6. I'm a non-resident. I had properties outside India, but when I came to India with an intention to stay in India, I become resident. What about my assets outside India? Should I sell them? No, I can continue to hold them. Similarly, I'm a resident. One is non-resident ma, other one is resident. I'm a resident. I acquired some properties in India. Now I left India. I'm leaving India to stay outside India for uncertain period. Now I'll be treated as non-resident. Sir, should I sell Indian assets? No, not required. Exemptions. Clear? Resident holding properties or resident, non-resident acquired properties from a resident. Similarly, non-resident had properties outside India, or non-resident becoming resident acquired properties from a non-resident. Resident acquired, not acquired, inherited. Resident inherited properties from non-resident. No need to deal with them. No need to comply with these norms. Exemption. Section 6 ma. Restrictions on PROI investments in India. PROI cannot carry following activities. Chit fund basis, of course, with state government approval, yes, allowed, but that too on non-repatriation basis. That means incoming allowed, outgoing not allowed. Incoming of foreign currency allowed, outgoing not allowed. Nidhi companies, investments in Nidhi companies not allowed. Agriculture, plantation activities not covered. Real estate business, construction of farmhouses also not allowed for non-resident. Except means these are allowed. REIT, townships development, roads, bridges allowed. So simply trading of real estate not allowed ma. Trading of real estate is not allowed. Construction related activities allowed ma. That means REIT related things, township development, roads development, bridges development, only those are allowed. And trading in TDRs also not allowed. Next, with respect to resident, for carrying capital account transactions, regarding loan amortization payments outside India, depreciation of direct investments in any business outside India, there is no restriction on foreign exchange withdrawals, no restriction. LRS restrictions are not applicable. Remember these 2 points also. No restrictions on foreign exchange withdrawals for loan amortization payments, depreciation of direct investments in business. Next one, sir, CAT cut important sir, very important ma. CAT cut very important ma. CAT means capital account transaction. That means any transaction that alters residents' net worth outside India or non-residents net worth in India. Any transaction alters residents net worth outside India or non-residents net worth in India, it is a capital account transaction. But coming to residents net worth, you have to take 3 amounts: assets, liabilities, contingent liabilities. Whereas for non-resident net worth, you have to consider only assets and liabilities. Any transaction other than CAT is cut. Any transaction other than CAT is current account transaction. But 4 items are specifically mentioned as current account transactions. Trade activities, short-term credit facilities, studies abroad, maintenance, hospital bills abroad. So these 4 amounts are current account transactions. One more item is there. Interest on investments, interest on loans are also current account transactions only. Investments, capital account transaction. Investment outside India, capital account transaction. But any income accrued on that investment, current account transaction. Next one ma, Schedule 3 current account transactions. Company can donate up to 1% of foreign exchange earnings from the past 3 years. 1% of foreign exchange earnings, average, that condition not applicable. 1% of 3 years foreign exchange earnings, or up to 5 million USD, whichever is lower, for the following things. Without RBI permission, they can do this. 1% of the foreign exchange earnings or 5 million, whichever is lower. It's not higher, lower. Next, agents commission, real estate agents commission, up to 25,000 USD or 5% of inward remittance, whichever is higher, RBI permission not required. Consultancy service remittances, up to 10 million USD for infra projects, up to 1 million USD for other consultancy, for other projects. Infra projects 10 million USD, other projects 1 million USD. Up to these amounts, RBI permission not required. Indian entity cannot remit more than 5% of investment brought into India or 1 lakh, whichever is higher. Pre-incorporation expenses, 5% of investment brought into India or 1 lakh USD, whichever is higher, you can do it without RBI permission. That means exceeding these amounts, RBI permissions are required. Remember, all are higher only. If you observe all the cases, you will find higher, but donations only one case you have to see lower, and this is for non-individual entities, not individuals. For individuals, LRS benefit is there up to 2.5 lakh US dollars per financial year. Prohibited current account transactions, you have to remember these points. Lottery winning remittances, horse racing winning remittances, purchase of lottery tickets outside India, payment of commission on exports made towards equity investment in joint ventures, wholly owned subsidiaries abroad of Indian companies, dividend balancing applicable companies. For dividend balancing companies, yes, prohibition is there. Payment of commission on exports under rupee state credit route also prohibited, but for tea and tobacco up to 10% of invoice value permitted, up to 10% permitted, above that prohibited. Callback services prohibited. Non-residential rupee special rupee scheme, remittance of interest income. A non-resident coming to India, his foreign money deposited in a non-resident special rupee scheme. On that some interest was added. If you want to withdraw this money, if you want to convert into dollars, whatever amount you invested, you can convert into dollars. You can withdraw that money, but interest amount withdrawal not allowed. Interest amount withdrawal in foreign currency not allowed. See, I'm not telling all these are illegal transactions, but for carrying these transactions, withdrawal of foreign exchange is not allowed. Prohibited. Schedule 1, prohibited current account transactions. Next one, resident but not permanently in India. LRS limit 2.5 lakh USD is there, right? But this limit is not applicable to the eligible persons except Pakistan citizens or Pakistan citizens. Indian citizens on deputation abroad can remit net salary. Just wait. On deputation basis, they came to India and they are drawing a salary after deductions, after tax, after PF deduction, whatever amount left over, if they convert into dollars, if it is more than 2.5 lakh USD also, they can withdraw. There is no problem at all. Person in India for employment deputation on specific assignment, that is up to how many years? 3 years. Next one, schedule 2, permitted current account transactions, but for this permissions are to be taken. Cultural tours, take permission from Ministry of Human Resource Development. Any payer, any payer. Next, advertisement. If payer is state government or public sector undertakings. Observe carefully, state government or public sector undertakings making advertisement in print media, not electronic media, in print media. That advertisement is for a purpose other than investments, tourism, international bidding, and that advertisement expenditure exceeding 10,000 USD, then Ministry of Finance permission is to be taken. So who the payer? State government, public sector undertakings. Next one, PSU paying freight of vessel, Ministry of Surface Transport permission required. Next one, payment of import through ocean transport. So payer is government department or a PSU. So Ministry of Surface Transport permission to be taken. Multimodal transport operators permission, registration certificate from DGS, Director General of Shipping, to be obtained. Remittance of hiring charges, TV channels, internet service providers, they need to take permission from Information and Broadcasting Ministry. Container detention charges up to prescribed amount freely permitted. Above the prescribed rate, Surface Transport Ministry permission required. Prize money, who is paying this amount? Other than international, national, state level sport bodies, if the amount involved exceeds 1 lakh USD, then also permission is required. See, first of all, observe the payer. If payer is ICC, BCCI, Tamil Nadu States Cricket Association, for example, so state bodies, central body, international body, permissions not required. Other than these people, others only required. That too, amount involved is greater than 1 lakh USD. If it is up to 1 lakh USD, permission not required. Remittance for membership of P&I club, Ministry of Finance permission is to be taken. Let's quickly see the FEMA also. Let's quickly see FEMA related master notes. So this 30 seconds or 1 minute, whatever you are seeing gap, I'm taking a rest. So fine, for me also fine, you can also take rest. FEMA, important chapter, 14 marks weightage chapter ma. So objectives of FEMA ma, to consolidate and amend laws relating to foreign exchange for facilitating external trade payments, orderly development and maintenance of foreign exchange market in India, applicable to whole of India, applicable to branches, offices, agencies outside India if owned or controlled by person resident in India. So here, yes, in residential status, this point I need to add, I'll add it, just wait. Definitions, give reading one time to the definitions, because there is a chance a definition may be tested for 2 marks. Read the definition: authorized person, dealers, changers, offshore banking units, any other person authorized to deal in foreign exchange. Capital account I covered, current account I covered. You can see here, foreign trade, short-term banking facilities, interest on loans, investment income, living expenses, maintenance abroad, foreign travel, foreign education, foreign medical care. So current account transactions only. Foreign exchange next foreign security. These two are important Foreign exchange, remember these points. Foreign exchange means foreign currency, no doubt at all, but also includes deposits, credits, balance payable in foreign currency, traveler check, bills of exchange drawn in Indian currency, payable in foreign currency, or drawn outside India but payable in Indian currency. Remember these 3 points. It can be tested for 2 marks. Chance is there. So drawn in Indian currency, payable in foreign currency. Drawn outside India, payable in Indian currency. But many students are missing these points Foreign exchange means foreign currency. 1 mark will be there. First, remember it. Foreign security means any security denominated in foreign currency. It's immaterial whether returns or redemption comes in Indian currency or not, immaterial. Person resident in India, these 2 points these 2 points are exceptional points. See, branch, office, agency in India resident, outside India also resident if it is either owned or controlled by person resident in India. For example Singapore company, yes limited, Singapore company had 2 branches. One is Mumbai branch, other one is Dubai branch. So Dubai branch is completely owned by Singapore, but if Dubai branch is controlled by Mumbai branch, Dubai branch is controlled by Mumbai branch, then Dubai branch also becomes resident. Exceptional point exceptional point. So citizenship is not a criteria. Residential status depends, a single person can have 2 residential status, like up to 1 period resident, remaining period non-resident. Gift whether it is a current account or capital account, that is really tricky point really tricky point. Gift, I'll see, let's see, but before that, section 3 if you want to deal with foreign exchange, you can deal with only through authorized person. You can deal with only authorized person. Other cases, dealing, making payments, receiving payments, financial transactions, allowed or not allowed? Not allowed. Next one, holding of foreign exchange. I'm talking about only resident. Resident cannot acquire, hold, own, possess foreign exchange, foreign securities unless permitted under FEMA notification. This is only for regulation of inflow and outflow of foreign exchange Next, import of machinery is a current account transaction. Why? Because resident's net worth is not getting affected because of import of machinery. Sorry, if I have taken loan, if that loan is for shorter period, current account only. If that loan is for longer period, not short term facility, long period facility, then it's a capital account transaction because I created a new liability outside India. A gift transfer gift, Indian resident giving gift of USD $1,000 to NRI brother in New York. Once gift is transferred, no asset, no liability is created in India. Therefore, it is a current account transaction. Suppose non-resident giving US dollars. Section 4, what it is telling? You can't hold foreign currency. Come and convert. If I'm converting, you tell me my asset outside India. Any creation of outside India asset, any new asset was created outside India? No. Then also it is also current account transaction. But one case, gift becomes capital account transaction. In which case, sir? See gift in Indian rupees from resident to non-resident. This creates an Indian asset for a non-resident, making it capital account transaction. In all other cases, gift is Current account transaction only. See, if I give $1,000 to my friend, current account, because no person's net worth affected outside India, in India. My net worth outside India, no change. His net worth in India, no change. But if I transfer in rupees to his rupee bank account in India, his net worth in India got affected. Non-resident's net worth got affected in India. Non-resident's net worth in India got affected. Capital account transaction. Getting my point? Suppose non-resident is giving gift to resident, allowed. However, funds given abroad, resident should repatriate them to India. He should bring them to India. Next one. Current account transactions covered. Yes, this also covered, ma. Exceptional points, ma. Exceptional points. Immigration, studies abroad. Sorry. Immigration, studies abroad, and medical treatment abroad. These three cases, if you have a valid proof, you can draw foreign exchange in excess of 2.5 lakh without any permissions from RBI. Proofs, country of immigration, medical institute offering treatments. Okay. LRS is applicable for persons, ma. It is not applicable to corporates, firms, HUF trust. For them, separate schedule is there, right? Donations, agency commission, we already discussed, right? Here, deputation basis, I already told. On deputation basis, he can withdraw net salary in foreign exchange. LRS limits also not applicable. And capital account transaction related special points are there, ma. This I covered. RFC, EFC, you can carry schedule 2, schedule 3 without any limits. Schedule 1 obviously prohibited, schedule 2, schedule 3 allowed. Whereas for EEFC accounts, P&I club membership fees, commission to foreign agents above $25,000 or 5%, whichever is higher. Pre-incorporation expense reimbursement above 5 lakhs or 1 lakh USD, whichever is higher. In these cases, permissions from central government is required. Family remittances clubbing rules, ma. Sir, I want to acquire an asset outside India. The asset worth is 5 lakh US dollars. But for me, LRS up to 2.5 lakh only, no. But I'm having one wife, sir. Only one wife I'm having. So can I use her limit to acquire that property outside India? No. But if the property is acquired in the joint names, that means if my wife and myself both become joint owners of the property, then clubbing of LRS is allowed. Clubbing of LRS is allowed. Minors can remit under LRS, but guardian must sign the declaration form. So capital account transactions covered. These 2 points, again I'm telling you, these 2 points are exceptionally important points, already covered. In 2 MTP question papers I have seen, they're asking, write any 7 permitted capital account transactions. Any 7 permitted capital account transaction. So just give one time reading. Transactions with no restrictions on withdrawals, you can see loan amortization, depreciation of direct investments. So this I covered. North Korea also covered. Oh my god, done. FEMA over. Next, exceptional topics. Last concept, General Clauses Act. For interpretation of statutes, I didn't prepare exceptional topics because the chapter itself is an exceptional topic. See, when I was a CA final student, the chapter is there in my CA final syllabus. I studied it for one day, but day before examination, everything looks good, everything looks new. So I had a strong relationship with that chapter. So the chapter itself is a exceptional chapter. So I'll show it in my master notes, don't worry. So now next concept is General Clauses Act. Important, 12 to 14 marks weightage. Preamble, you can refer to preamble only if there is an ambiguity in the provision. Suppose if there is a conflict between provision and preamble, preamble cannot override provision. May, optional, shall, mandatory. But sometimes may you have to interpret as shall you have to construe it as may. Means exhaustive definition, includes inclusive definition. Document definition, 4 components, 4 items, 4 conditions to be satisfied. But document excludes Indian currency notes. Remember, document excludes Indian currency note. Document includes electronic records and computer files. Immovable property, right to access roads, is an immovable property, but right to drain water is not an immovable property. Right to grow fishes in a water is also immovable property only. Benefits associated with the land, benefits that arise, remember, benefits that arise in future is an immovable property. Sir, already arised, not an immovable property. September 25 attempt question paper, you go through it. Rent in arrears is not an immovable property, but future rents is an immovable property, because benefits associated with the land that will arise in future, immovable property. Already arised, not an immovable property. Effect of repeal. Repeal does not revive old things. Repeal does not affect past actions. Repeal does not affect rights, obligations, liabilities already created. Not affect penalties, punishments. Not affect ongoing further legal proceedings. Suppose, under old Companies Act I got certificate of incorporation. Under new Companies Act, is it valid or invalid? That means shall not affect past action. I'm already shareholder under old act. My rights affected under new act? No, my rights, company obligations. I did a mistake under old act and I got punishment. Any change in punishment after commencement of new act? No. Suppose punishment I did it, but proceedings now it happened. Proceedings right now started. Can they carry out the proceedings? Yes. Coming into operation of the enactment, remember, notified date. Notified date is the commencement date. If no date is notified, if notified date is not mentioned, then when president gave consent, from the date onwards, act comes into the force. Midnight 12 o'clock, the date midnight 12 o'clock, from that time onwards rules comes into the force. Prosecution under two enactments is not bad. You may be prosecuted under two acts, but punishment wise for the same offense under two acts is prohibited. If the offense is having two or more ingredients, one is covered by one act, other is covered by another act, and there is a difference. There is a difference of the offenses. Offense mentioned in Income Tax Act is different. Offense mentioned in Money Laundering Act is different. If you committed both the offenses, you will be punished under both the acts. For same offenses, punishment wise is not allowed, prohibited. But prosecution allowed. Prosecution. Proceedings can be carried out, punishment only one. Where statute requires registered post acknowledgement due, service by registered post acknowledgement due is required. That means service by registered post alone is insufficient. Time came, that's why I'm telling. Section 20 company in AOA they told that yes, service of documents through email, but one member requested company not to serve over email. I want a notice hard copy. For this, he also deposited sufficient amount. Now, company should send notice as per the directions given by the person, or else it is intentional omission of the notice. All the proceedings, all the decisions taken at the meeting stands null and void. Citation by next one, refusal to accept registered post amounts to deemed service. I'm sending letter. If you are not accepting it, I assume that it is valid service of notice only. Citation by short title and year is also valid. Companies Act 2013 or Act number some 18 of 2013. So both are valid only. Next one, notification can be modified only by another notification published in the official gazette. If you want to modify earlier notification, simple discussions, a small paper declaration is not enough. Again, fresh notification to be given, then only it will come into the force. New notification will come into the force, or else changes will not take place. Power to issue includes power to amend, power to vary, power to cancel the notifications. Notifications rules continue in force unless expressly withdrawn. Old Companies Act got repealed. What about the rules? Unless otherwise mentioned, rules will be in force only. Suppose under New Companies Act we didn't mention any rules, so you can take reference of old amendments, old rules, old notifications. Gazette publication is conclusive proof of valid rule making. Previous publications, through official gazette announcement only it becomes valid, it becomes enforcing. Power may be exercised from time to time, so there is no limit on number of times exercising the power. You can exercise whenever if you want to exercise the power. Whenever occasion demands, you can exercise the power. Appointment may be made by virtue of office. I can appoint a person through his name, or I can appoint a person through his designation. Like IEPF authority, chairperson. Who is the chairperson? Secretary of MCA. So appointment includes ex officio appointment. Power to appoint includes power to suspend, power to dismiss. Successor powers, powers of the predecessor automatically transfer to successor. Action of lawful deputies, chiefs, in the absence of chief officer, subordinates can exercise those functions. From excludes first day, to includes last day. Duty to payable on pro rata basis. If something, pro rata, for example, for 100 units you have to pay 500 rupees duty. For 50 units, proportionately 250. For 150 units, proportionately 750, pro rata basis. Male includes female, singular includes plural, but if there is an specifically indicating, specifically if the gender is indicated, then you can't take such assumption, like woman director, you can't take other stand. Getting my point? Previous year, you have to pay income tax with respect to income earned in previous year. There singular means singular only, singular doesn't include plural. Previous year means previous year only. Distance shall be measured in straight line on a horizontal plane. In capital gains, property, urban property or rural property, you had a limits, right? 2 kilometers from the municipality. So how to measure the distance? Straight horizontal plane from municipality to location of the property. It's not road route, it's not road route or train route, it's like aeroplane route only. So distance shall be measured in straight line on a horizontal plane. So let's go through the master notes ma. Object of the act ma. Object of the act, give one time reading, important ma. Shorten the language of central acts. Provide uniformity of expression in central acts. State explicitly certain convenient rules. Guard against slips and oversights. General Clauses Act doesn't have its own independent territorial extent. Its extent depends on all other central laws. So old General Clauses Act, yes, I have seen it in somewhere. In MCQ, I think I have seen it. Old General Clauses Act numbers also. First, present General Clauses Act 1897. Previous General Clauses Act. Just one second. Yeah. Definitions, one point, is there, right? Just a moment. Means includes, yeah, definitions. 1 second, ma. 1 second. Yeah, here you can see. Old General Clauses Act means first General Clauses Act 1868, second General Clauses Act 1887, present General Clauses Act 1897. 1868, 87, 97. Okay, na? In one MCQ I have seen it. May, shall, means, includes, give one time reading, simple only. Definitions. Affidavit ma. Affidavit declaration important ma. It includes affirmation and declaration by those allowed to affirm or declare instead of swearing. A written statement conferred by oath for legal use. Same definition applies to oath or swear also. Declaration of affidavit important. Financial year, generally April to March. Calendar year, January to December. Both are different. Good faith. Tricky point. Good faith. As per General Clauses Act, good faith means doing something honestly, whether you are negligent or not. But as per Indian Penal Code, as per civil laws, as per Indian Contract Act, having honesty itself is not sufficient. You should not be a negligent. You should not be a negligent. So as per General Clauses Act, honestly, but other laws, as per Indian Contract Act, if you see, as per Indian Penal Code, if you see, civil laws, you see, just honest purchase, you can see here, honest purchase made carelessly. Honest purchase made carelessly without proper inquiries cannot be said to be done that act has been done in good faith. Okay. Immovable property, land, benefits arising from land, things attached to the land, earth, permanently fastened, something attached to the earth. Masima, grown up crops, trees, fruits, until separation from the land, they are immovable properties only. Once separated, they become movable goods. Timber is a movable property. Tree, uncut tree is immovable property. Timber is movable property. So right of way, immovable property. Right to drain water is not. Standing crops, fixed machinery are still considered as immovable property because these are the benefits arising from the land. Once you cut it, that's it, they become movable. My imprisonment, by description, two descriptions having rigorous, that means hard labor, simple. no labor. Act under General Clauses Act, act means negative thing. It's not, it's an activity. Act means activity. So omitting to do the things, legal things. You are bound to do the things, but you are not doing the things, or doing things which are forbidden by Indian Penal Code. Then we call it as act, offenses. So general rules 5 I told you. Commencement time, commencement date, specific date, no specific date, then president consent date. Courts had no permission, courts had no power to demand government to bring the laws. Remember, courts had no power to demand government to bring the laws into force. Repeal I covered. Repeal of act making textual amendments. Repeals any enactment, amendments made to another law, those amendments still remain valid. Amendments part valid only. Tax Amendment Act is repealed, tax rate still valid only. If you want to revive repealed enactments, express disclosure is required. Construction, references automatically updated with reenacted act. So commencement time, from excludes to includes. Time, if a due date falls on, important if due date falls on holiday, then it's enough if you comply with the directions the next working day, certain day within the prescribed period is closed. You can do it on the next day when court or office is open. Distances, horizontal line, told you, pro rata completed. Gender, number also completed. So all these I covered all these points I covered. Officials, chiefs, subordinates. Simple chapter only so don't take choice of this chapter. Enactments 22-24 also I covered. Miscellaneous part also covered. Recovery of fines, for that go with IPC Go with IPC. IPC and provisions of CRPC will apply for recovery of the fines. Prosecution allowed. Offender can be prosecuted but not punished twice. Service by post means properly addressed, prepaid stamps, posted by registered post. Enough. Citation of enactments. Title, short title, yes, number, year. So Companies Act may be cited as Act number 18 of 2013. Ordinances, central acts include ordinances. That's it General Clauses Act also over. Interpretation of statutes, I won't explain much, but just I'll tell you the important points. Don't forget. Document, remember, document excludes Indian currency note. Document includes electronic documents electronic records and computer files. So in interpretation of statutes, chapter is of two parts I'll just give you overview of interpretation of statutes here itself. Interpretation of statutes, two parts. Aids to interpretation, again two parts. Internal, external. Read it once, important internal, external. And second one is general principles of interpretation, general rules of interpretation. I'm sorry, rules of interpretation. These are of two types: primary rules, secondary rules. Primary rules, secondary rules. If you see the same thing, interpretation, instrument, deed, document. Remember, every deed is an instrument, every instrument is a document, but every document need not be an instrument, every instrument need not be a deed. So document creating rights and liabilities become instrument. Instrument with witness, in case of witness is there, partnership deed, MOA for example. So deed. Interpretation versus construction, one time reading. Interpretation versus construction, one time reading. Literal interpretation, doctrinal interpretation. So authentic, get the meaning from the language used in the law. Usual interpretation, get the meaning from the customs. Doctrinal interpretation, grammatical, go with the grammar used in the act, go with the language used in the act. Logical interpretation, beyond the words used in the law, In regular class and marathons I gave examples. If you want, you can watch marathon. In marathon I covered. Next one, construction versus interpretation, give one time reading. Importance of interpretation, construction, one time reading only. Next one, rules of literal interpretation. Try to remember 5 to 6 points. If asked for 4 marks, you can write the remembered points, right? Without, why to ignore it? If you are capable person, able to remember, give one time reading. A reasonable construction, Heddens rule, mischief case, beneficial construction, exceptional construction. Ugisdem generis exception cases, remember ma. Ugisdem generis exception cases, important. Specific general words are broad, specific words cover entire category, specific words are diverse in nature. Law explicitly states that Ugisdem generis is not applicable. If you remember this, quite opposite, you can write conditions for utilization, conditions for application of Ugisdem generis. Specific words, common category, not fully covered, no indication. Doctrine of Nostita Ausosis, give one time reading. Contemporaneous exposition, these two are secondary rules, give one time reading. Internal aids, external aids, generally, 2 points can be tested for 4 marks ma. So just give one time reading. So with this, I'll conclude this exceptional topics marathon. So I wish you very all the best for your upcoming examinations. Make use of these resources. It will be really helpful. Hardly, I think, 3.5 hours. 3.5 hours I took your time for completion of this exceptional topics marathon. Again, I wish you very all the best. Again, we will meet on accounts examination day. After completion of your accounts exam, you need to see me. Fine. Take care. Bye bye.